I see everyone is ready. See the court reporter is ready as well. So I'm very pleased to be able to welcome you all here to this hearing. I must say that after almost 3 weeks of online hearings, it is very nice to see real people, and so you're very welcome here. I will start with the introductions. You do know the arbitrators, Mr. Johnson on my left, Mr. Luke on my right, the secretary of the tribunal, Ms. Rosenberg, on my far left, and on my far right, the assistant to the tribunal, Mr. Langer. Now let me turn to the claimants first, and maybe the easiest is that I give you the floor, Dr. White, and you will then either you present the people who are here, or each one mentions her name.
Sure, thank you very much, Madam President. To my immediate left is Mr. Timothy Foden, and to my far left is Mr. Augustin Barrier. To my immediate right is Ms. Eden Jardine. To my far right is Mr. Robert Dennison. And then at the back, client's representative, Mr. Andrew Thompson. Then Dr. Mark Sander. Then we have witness and party representative Richard Williams. And then we have our quantum expert, Miss Vicky Wall. And also from Kroll, Mr. Johnny Davies.
Thank you. These are all that I have on the list, so everyone's present, and that's perfect. We can start. Then let me turn to the respondent and give the floor to you, Mr. Luende. Mr. Luende, if you will do the talking in general over the days for the respondent, would you mind sitting a little bit more? Not now. We can do this in a break. It's not a problem. It's just that otherwise I don't see you well. It's important that I do see you. No, you don't have to do this. No, but you can get organized a little differently during a break. So, Dr. Luende, can I give you the floor to introduce those who are here on behalf of Tanzania?
Thank you, Madam President and the honorable members. My team is constituted of Counsel George Mandepo, just raise up your hand. Madam Salome Magesa, who is also a counsel. Madam Concessa Kahendaguza, Neisha Shao. Then we also have party representative Malia Leonard Mwakivete. Then we also have Counsel Hadija Bakari Ramadan. We have party representative Mr. Damian Kaseko. We have Counsel Andrew Lugarabam. We have Counsel Ipiana Mlilo. We have Counsel Lydia Thomas. Then we have our three witnesses, Professor Abdul Karim Mruma, Mr. Andrew Mwangakala, and Mr. Edwin Igenge. There are two more party representatives. Unfortunately, they are not here, so we'll introduce them when they get here. But that is the team we have for now. Thank you, Madam President.
That's very good. You know now I should see whether the representative of the Trade Law Bureau of Canada is on the line. Mrs. Murphy, do you hear me?
Yes, I can hear you, Madam.
Oh, excellent. So we don't see you here in the hearing room, but you understand that you will participate remotely, and that this is an opportunity to welcome you as well. In terms of program, we'll follow the agenda as it is set out in Annex C of PO5. The rules that we will follow are those set out in Procedural Order number 5 and partly also in Procedural Order number 1 and Procedural Order number 2 in respect of transparency. We will have the Zoom session running throughout the hearing. Today we will hear oral arguments for starting with the claimants, of course, and then continuing this afternoon with the respondent, maximum 3 hours each. The total time allocation, including the oral argument, is 9 hours and a half each as a maximum over the days of hearing. I noted that the respondents' witnesses are currently in the room. If I'm not mistaken, but I would need to check this, they should not attend the hearing before they testify, but let me just check this. It should be in procedural order number 1, I assume. Yeah.
Yes, will not be present. It's procedural order number 5, paragraph 37.
Yeah, it's 1 and 5. Fact or quantum witnesses shall not be present in the hearing room during oral testimony and arguments or read transcript of oral testimony or argument prior to his or her examination. This limitation shall not apply to expert witnesses or to a fact witness who is also a party or party representative. And then we made an exception for Mr. Wangakala to attend the claimant's expert examination, but we didn't make this exception for the oral arguments. So, gentlemen, I'm very sorry, but you will have to retire to the breakout room until you are called to testify. Is that fine, Dr. Luende? Or Mr. Mandepo?
It's fine, Madam President.
Good.
Yeah, it's fine.
Fine. So can I, let me just ask before we start, is there any comment or questions to be raised on the claimant's side?
No, Madam President, other than that, you know, our understanding was as it was in PO5 and as you just recited it.
Yeah, we'll simply follow what we have said before. Is there any other question or comment from the respondent's side, Mr. Mandepo?
Madam President, I think the rule applies the same ways to the claimant as well, for their witnesses to get out.
They have a witness, Mr. Williams, who they have designated as their party representative. And there is an exception for party representatives, but you will remember that I think Friday, the tribunal wrote to the respondent asking whether one of the witnesses is a party representative. And you could still, I would suggest, make the decision if one of the witnesses is also a party representative, he could stay on, the other two could not. So I don't know whether you want to briefly discuss this within your team and see how you wish to handle this.
On our side, we can allow them to get out, but I understand that the claimants have introduced two parties representative there. I think
but
want to be
the only party representative who is in the room and he is an expert right now is Mr. Williams. Then there is the quantum experts, and they can attend. There's no rule against attendance of experts, and that is because it is generally thought that experts just give their testimony on their objective knowledge, and they are not meant to be influenced in respect of facts because they say nothing about the facts themselves.
Okay, we have understood, Madam President. Thank you.
So if you wish to designate one of these three persons as a party representative, he can stay. Otherwise, they would. That is up to you. That was the meaning
we
of
yesterday
what
sent a list of updated list of our team, so we don't think that we can amend again.
Yeah, that's what I
So, yeah,
understood from the updated
yeah,
list.
Thank you.
Fine.
Yeah, so we understood. Thank you.
That they all three have to withdraw now. Yeah. Can you please ask them to do this?
I think Yendo Mwangakala, you allowed him to remain, so we can ask two of them because we have only three witnesses.
Yeah, but you have to formally tell us who among the three is your considered a party representative.
Thank you, Madam President.
Did I miss something? You said Mr. Mandrakala. Yeah, that does make sense indeed.
Yes.
Yeah. Fine. Sorry,
yes.
I didn't get you right.
Yes. Yes,
So that would mean that the other two,
only two, Professor Mruma and
Mumra and
Genge.
Mr. Ingenge.
Yes, yeah.
Yes.
Fine. Good. Then if there's nothing more in terms of housekeeping, Dr. White?
Yes, there is, Madam President. If we look at procedural order number 5, section 37, it says that party representatives have to testify first. So it is our position that if Mr. Mwangakala is now designated as party representative, he should go first in the cross-examination.
Yeah, that makes little sense actually in terms of the order of the witnesses. Yeah.
Mm-hmm.
Yeah. Because he really comes, yeah, I have it, thank you. He really comes last because he's somehow answering Mrs. Wall's report. And if we change this, it will be quite confusing. And it will not be good for the tribunal because then we don't really understand the evidence on quantum correctly, which is not the purpose.
I think the only reason we're doing this is so the party representative can then stay in the room after testifying. And
Oh, you can leave. But, yeah.
so we could leave the order as it is, which makes more sense. That person then just has to stay out.
But then they can choose another one.
Maybe they should.
Yeah. what the tribunal would like to say is that we do not want to change the order of the experts, because as I mentioned, this would be quite confusing. That would then mean indeed that Mr. Gwangakala could not be the one who's the party representative, because that would then go against the rules that we have set. Another possibility would be that you designate another one of the two who left, if you wish to have one with you.
Okay. Thank you, Madam President, and we. Sorry, I was saying that if we have an issue with the designation of Mr. Mwankakala, would want to change that order so that Mr. Mwankakala can leave the room, and then we designate Professor Mruma as a party representative. If that is acceptable, then we can proceed from there, Madam President.
Fine. And then let me look at the... He's right now the first respondent witness. So does it mean that he has to be heard first among the respondents' witnesses, right? I think that's fine.
Sure, yeah, we
We're
have
not
no,
yeah.
we have no objection.
Yeah, so that's fine then. That works much better, because Mr. Mbruma is in any event your first witness.
Thank
Fine.
you.
Can we then make the change?
Yes, please. Thank you very much, Madam President.
Fine.
So we can proceed in that order.
Fine. That's fine with everyone. Yeah.
Certainly.
Good. So while they're making the change, we have received the claimant's opening submission that was uploaded on Box, and we would be ready to start with listening to the claimant's opening. You have 3 hours. Sometime around the middle, we would have a break, but we will decide what the best timing is for that.
Okay. That's fine. So thank you, Madam President. I'll hand over to my colleague, Timothy Foden.
Good morning, Madam President, members of the Tribunal. You know, when I began practicing investment arbitration, I assembled a library of treaty awards dating back from the 1970s through the 2000s. It was all in paper, it was velo-bound, it was quite unwieldy, and it took up an entire bookshelf in my office down the street. And many of the awards in that library predated the storm that now swirls around investment treaty arbitration, and they dealt with relatively simple fact patterns. Think, for instance, of those classic cases of Liamco versus Libya or Letgo versus Liberia. Now, these are cases where a state abolished a license or a concession, often out of resource nationalist motives, without offering the holder any compensation. When that happened, international tribunals expeditiously issued awards in favor of the claimants. There was very little controversial about these decisions. They reflected norms that were accepted by the community of nations and put into effect by those states and the intellectual father of this very institution we sit in today, Aaron Barocius. And those norms were, in short, states have sovereignty over their resource wealth and are entitled to nationalize private ownership of such resources if they so wish. But if they do, they have to do so for a public purpose, in a non-discriminatory manner, in accordance with due process of law, and, crucially, they have to offer prompt, adequate, and effective compensation. Those principles have been recited again and again in ICSID and other investment treaty awards since then. Of course, investment treaty arbitration has gone through a boom since those days. In fact, patterns these days are often much more complex, and tribunals have developed a body of jurisprudence that would extend far beyond my old bookshelf. However, this dispute, at its heart, is a thing of the past. Legally, it has much more in common with those old nationalization cases than some of the complex right to regulate modern treaty cases with which this tribunal is so familiar. And its simplicity lies in this. Beginning with the presidency of Benjamin Mkapa, and over the course of 20 years, Tanzania rolled out the red carpet for investors in its mineral sector. Foreign mining companies around the world invested considerable sums into exploring and developing Tanzania's vast mineral wealth, the claimants here, of course, included. However, in 2015 and 16, a new president, the late John Magufuli, gained power in Tanzania, and with him came a radical shift in policy. He commenced a self-proclaimed economic war on mining companies. Stoking a fire of resource nationalism, President Magufuli's government overhauled the mining legal framework that had been in place for 19 years, shifting the economic environment from one where the legal rights of investors were protected to one where they were trampled upon, to give way for populist perceptions of national interest. As part of President Magufuli's economic war, Tanzania didn't just retroactively cancel the claimant's license, it also abolished the whole retention license category without explanation. Did Tanzania offer prompt, adequate, and effective compensation? No, it did not. Tanzania failed to offer the claimant any form of compensation for this archetypal act of expropriation, leaving them no choice but to vindicate their rights under the Canada-Tanzania Bilateral Investment Treaty. So here we are, presented with the case that belongs on my old bookshelf, with the other classic expropriation cases I studied when I began practicing in this fair city. But what did Tanzania expropriate? The SMP Gold Project, which you see on the screen before you. It was a 12-year-long project to explore and develop a gold mine in southwestern Tanzania, in the country's second largest gold field, which is known as the Lupa Gold Field. In pursuit of its project, the claimant injected millions of dollars into exploring, discovering, and delineating commercially significant gold deposits along a geological formation that's known as the Saza Shear Zone, over which it had acquired mineral rights through its Tanzanian subsidiary, Bafex Tanzania Limited, or what we call it, BTL. Now, along the way, the drilling results and the claimant's commitment to responsible mining exploration and community engagement prompted the IFC, a fellow division of this very World Bank, to invest 6.2 million Canadian dollars into the project. Now, as part of the claimant's overall investment, it provided employment opportunities and infrastructure in neighboring communities. And the claimant would have invested more, but for Tanzania's actions. Now, the sad reality underlying this case is that Tanzania has denied not only the claimant, but itself and its own people the opportunity to benefit from all that investment. And to what end? Now, you're likely to hear from the respondent this afternoon that its measures were all introduced in good faith or to create a, quote, win-win situation for investors in the country. But pardon me for not accepting that management speak platitude in these unfortunate circumstances. We have seen zero evidence to explain how the measures that affected the claimant, namely repeal of their entire license category and retroactive cancellation of existing licenses, were in any way related to a rational policy goal. Indeed, Tanzania can point to no public committees or consultations, no reports, nor any studies on the retention license category that would have prompted their repeal. It took place almost overnight through a seemingly baseless emergency procedure and after the government held a one-day public consultation that was clearly a charade, a mere box-ticking exercise rather than a genuine attempt to engage with stakeholders. Rather, the evidence that we have on record and the gaps in that evidence that the respondent has willfully refused to fill show that President Magufuli's economic war was likely one between his government and one company in particular. That company was Acacia Mining, a then subsidiary of the global mine conglomerate Barrick Gold Corporation, and it owned 3 of the largest gold mines in Tanzania. President Magufuli's new government set on a warpath against Acacia in 2016, and all foreign mining companies in Tanzania suffered collateral damage as a result. To give an example of Tanzania's overzealous stratagems in this war, in July of 2017, the government sought to impose on Acacia a staggering $190 billion fine alleging non-payment of taxes. That is an extraordinary figure. It's several times the size of Tanzania's entire national GDP and equivalent to 2 centuries of Acacia's revenue. Now, to be clear, the president dispute isn't about the wranglings between President Magufuli and Acacia cum Barrick. We don't know or even care about the rights and wrongs of that particular battle. As our friends opposite will likely remind the tribunal today, Tanzania's measures against Acacia were, in a sense, successful because Barrick entered into a settlement agreement with the state. And now the whole dispute has simply gone down the memory hole, to use an Orwellian phrase. What we do care about, though, and what this tribunal must determine, is whether Tanzania's actions in its economic war against Acacia affected the claimant's investment in a manner that breached its obligations under the BIT. For the reasons that you're going to hear today, they did. The respondent's breaches of the BIT unfolded in 3 principal measures. Measure number 1 was Tanzania's abrupt and ill-planned legislative overhaul of the mining framework. During a highly irregular process that lasted a mere 7 days, in June and July of 2017, President Magufuli's government published and then drove through Parliament 3 bills that radically changed Tanzania's mining laws. Those bills passed into law on the 10th of July 2017 and became the statutes that we refer to as the amending legislation. Those 3 statutes are set out on the slide in front of you, and the full names are there, but we call them the Unconscionable Terms Act, the Permanent Sovereignty Act, and the 2017 Act. Now, I'm going to focus on the 3rd of those statutes, but let me give you an idea of just how far-reaching and politicized the unconscionable terms in the Permanent Sovereignty Act were, by reference just to a couple of their provisions. The first, the Unconscionable Terms Act, opened up all existing and future resource contracts between Tanzania and mining companies to parliamentary review, and, if deemed to be contrary to Tanzania's interests, nebulously defined interests as they were, forced renegotiation. All indications are that this law's never actually even been used. Meanwhile, the Permanent Sovereignty Act, which referred expressly to resource nationalism in its preamble, attempted to ban international arbitration by proclaiming all disputes arising from the extraction of natural resources were to be heard by the Tanzanian courts. Now, obviously, this was just posturing. Tanzania can't avoid its international obligations simply by rubber stamping hastily written domestic legislation. But the uncertainty that those measures generated, whilst President Magufuli was shouting to the world that he would, quote, close all the mines if foreign investors refused to negotiate with the state, affected dramatically the view the mining community took towards Tanzania as an investment destination. However, despite all the furore, there was one particular measure hidden away in the legislation overhaul that affected the claimant most acutely. Now, as you'll hear from my colleagues, the pre-existing mining legislation had provided for three principal license categories. One of those license categories was the retention license. It was a license that was designed to allow an investor to retain tenure over a deposit that had prospected where there were technical, economic, or market factors that prevented its immediate development, particularly like a depressed mineral price. The claimants in this case held 4 retention licenses for the SMP project. Now, the measure that I'm referring to was part of the third of the 3 acts, the 2017 Act. The extent of the measure's harm, because it's actually given rise to 3 separate investment treaty claims that we know of, is understated by the Act's concision. Now, I'm going to read from Section 16. It just says, the principal act is amended by repealing sections 37 and 38. Now, if you don't know what those sections are, this amendment doesn't seem too far-reaching. But those sections were the provisions that established and governed the entire retention license category. Without them, the Mining Act 2010 just no longer includes that category. Now, this happened without any prior notice or any warning, and it came with no explanation. The claimant attempted to obtain clarity from the government on the impact of the amending legislation on existing licenses, but couldn't find an audience with any government official who had any answers. Even the Canadian High Commission, which had promptly mobilized its resources to assist Canadian companies in Tanzania, couldn't get any clarity from anyone at any government level. Now, it certainly didn't help that President Magufuli had fired the incumbent Minister for Minerals in May of 2017, just 2 months before it enacted the amending legislation. Yes, you heard that correctly. The government enacted sweeping changes to its mining regulatory framework with no sitting Minister for Minerals. So it appears that not only did the relevant portfolio minister seemingly have no input on the amending legislation, there was no one there to implement the new framework or to listen to the outcries from the dispossessed retention license holders. When a new minister was finally appointed 4 months later, in November of 2017, it became pretty clear relatively quickly that the Ministry of Minerals wasn't in a position to provide the much-needed clarifications concerning the impact of the amending legislation on existing retention licenses. The government then told the claimant that it was working on the matter and that the claimant would be informed of the status in due course. The newly appointed minister similarly told the Canadian High Commission that it would examine each and former retention license on a case-by-case basis. In short, Tanzania left retention license holders in a state of limbo, utterly in the dark as to the status of projects that they had developed for years. And now, we reach measure number 2, and that's Tanzania's cancellation of the claimant's retention license. Now, on the 10th of January, 2018, a full 7 months after passing the 2017 Act, Tanzania finally got around to enacting its implementing regulations. Again, it did so without any warning or without any consultation of industry stakeholders. We call the implementing regulations the 2018 regulations. Now, where the 2017 Act had left retention license holders in doubt as to the status of their license, the 2018 regulations gave clarity. Unfortunately, it just wasn't the type of clarity that our client had hoped for. I'm going to read from Regulation 21. It says, Subregulation 1, all retention license issues prior to the date of publication of these regulations are hereby canceled and shall cease to have legal effect. Subregulation 2, consequent upon cancellation of retention license under subregulation 1, rights over all areas which were subject of retention license are hereby and without further assurances reverted to the government. That was that. Tanzania had simply taken the rights to the claimant's project. As I mentioned at the beginning, Tanzania provided no compensation for doing so. But at least initially, it appeared to the claimant, that it might. As you're going to hear from the claimant's witness, Mr. Richard Williams, over the following 2 years, the government strung him along on the promise of a substitute license under which BTL would be able to continue the project. The government, through then Deputy Minister Biteko, represented that it wanted BTL to pursue the project under an alternative title. Again and again, the government told the claimant to apply for a new license of some kind, or just wait another few months, we're working on a solution. But, invariably, Tanzania ignored the claimant's approaches and failed to provide any solution whatsoever. The claimant was, once again, back in limbo. However, finally at the end of 2019, there appeared to be some light on the horizon. By a letter dated 20 November 2019, the Commissioner for Minerals informed BTL that, quote, the government is preparing a framework/procedure for issuance of licenses in areas formerly covered by retention licenses. That's Exhibit C202. It seemed like the government was finally going to permit the claimant to pursue the development of the project. Now, the events that followed that assurance proved it to be entirely disingenuous. That's because on the 19th of December 2019, we come to measure number 3, which is the tender process. Now, only a month after the Ministry of Minerals assured my client that there would be a process for returning retention licenses to holders, the Mining Commission announced a public tender to bid for new mining licenses. The license areas in question, well, they were exactly the same as those that had been previously held under retention licenses. In other words, far from returning the claimant's project area under a new license, Tanzania announced that it was just going to auction it off to the highest bidder. Tanzania didn't give the claimant any notice of the tender announcement. Indeed, my client only found it by stumbling across it on the ministry's website. What Tanzania did do, however, was admit that the claimant deserved compensation for the taking of the project. This is Exhibit C11. Contained within the tender documents was a condition that the successful bidder would have to commit to compensate the previous license holders for their exploration costs. Now, this should be seen for what it is. This is an admission of liability. And indeed, it seemed that Tanzania realized that as well. And that's because the very next day, lo and behold, the admission of liability was gone. On the 20th of December, Tanzania replaced the original tender document on the Mining Commission's website with a new one, and there was only one change. That provision regarding compensation to previous license holders had been excised. By way of its tender, Tanzania confirmed once and for all that it did not recognize that the claimant had any right to an alternative license for its project, and that it wouldn't provide any compensation to the claimant for depriving them of that right. It had completed its expropriation of the project. Accordingly, the claimant resorted to its rights under the BIT and commenced these proceedings that we sit in today. But that's not quite the end of the story. In its defense, Tanzania argues extraordinarily that it couldn't have expropriated the project because it didn't subsequently give it to another investor. Well, not only is that wrong as a basic matter of international law, it's simply not true as a matter of fact. Since these proceedings began, the claimant has obtained satellite imagery showing that another organization is mining the very mineral deposit that the claimant spent years exploring and defining. The satellite imagery before you depicts a sophisticated array of cyanide leaching tanks used to extract gold from ore. just look at those photos. That is a fully developed commercial mine site. We've got additional photos that we have not put on the record. If the tribunal would like to see them, we're happy to provide them. But they're more recent, and they depict the size and scale of the operation at the SMP project. You're going to hear more about this later today from Mr. Barrier, and again from Mr. Williams when he testifies. Now, our friends opposite will also tell you that the tender could not have been an expropriation because the tender itself was actually illegal in that it hadn't been published in accordance with Tanzanian law. This is, of course, no excuse for the respondent, but I'd invite this tribunal to treat it for what it is, an admission that Tanzania did not provide due process when it expropriated the project. Now, we're also likely going to hear at some point that this tender document lacks authenticity. This is an argument the respondent made for the first time in its rejoinder, that unless a document is stamped with some governmental seal, it's fake, which is bizarre in respect of the tender document if you think about it, because the document gets stamped when the government receives it, not when it issues it itself. And not only is it an untimely argument, but it's one that's an entirely blinkered way to approach issues of evidence in international arbitration. Tanzania itself has adduced documents in these proceedings that lack a stamp. Now, you'll also hear from Tanzania that it offered the claimant a special mining license and that the claimant turned down that offer. Tanzania will argue that that means there was no unlawful expropriation after all. But this offer was not an offer of prompt, adequate, or effective compensation. It was merely an invitation, as highlighted on the screen, to apply for a special mining license. There was no guarantee that Tanzania would have granted such a license. And, in fact, having not been able to work on the project for 4 years, the claimant wasn't in a position to meet the requirements for a special mining license. So again, by doing so, Tanzania would have breached its own laws if it had granted my client a special mining license, should it have decided to apply. However, more damning is the timing of that offer. It arrived on the 17th of February 2021, during the pendency of these very proceedings. This was too little, too late. Or, as Mr. Williams puts it in his second witness statement, the damage was already done. Now, what else have we heard from the respondent in its defense? Well, the justification the respondent turns to time and time again is this, that it has the sovereign right to change its own law and sovereignty over its natural resources. But this argument is besides the point. No one is disputing the respondent's rights as a sovereign state to enact laws or to nationalize assets. However, when Tanzania signed the BIT, it agreed to circumscribe its own right to enact laws and to nationalize assets. It agreed to comply with the obligations it undertook to investors like the claimant in the BIT. Canada agreed to do the same in respect of Tanzanian investors. If by its enactment of laws or its nationalization of retention licenses, Tanzania breaches its obligations that it freely agreed to, which it has done, it must incur international responsibility. In other words, yes, Tanzania has permanent sovereignty over its resources. And yes, it can expropriate those resources from foreign investors. But under international law, and because it signed the BIT, when it does so, it has to provide compensation. It's got to pay. Tanzania hasn't paid, so we need this tribunal to issue an award ordering it to do so. Now, in realization that it can't turn to international law to justify its expropriation, the respondent has decided to cast doubt on the validity of the claimant's investment and its eligibility for a retention license in the first place. Now, with respect to illegality, Tanzania contends that the claimant's investment was illegal because it only submitted 4 quarterly reports, it didn't declare bank loans, and because the company changed its name in 2021 after Tanzania had already expropriated its investment. Now, I'm not going to dignify that last defense with a response. With respect to the bank loan defense, even if it could deprive this tribunal of jurisdiction, which it cannot as a matter of international law, it's premised on a piece of 1998 guidance handed out to Tanzanian banks, not, as the respondent suggests, Tanzanian banking regulations. In truth, the cash advances and advances towards share capital the claimant used to finance BTL's exploration activities were not formal interest-bearing loans, and thus they were not caught by Tanzania's registration requirements. God bless you. As it does frequently, Tanzania has just read new requirements into its own law in order to avoid liability. Similarly, this quarterly report defense represents a remarkable sign of Tanzania's uncooperativeness in this fact-finding exercise. Tanzania has maintained that objection, even in the face of the claimant submitting 514 quarterly reports as exhibits, some 70% of which bear stamps proving their receipt by the Ministry of Minerals. Now, finally, the respondent argues that the claimant didn't comply with provisions of Tanzania law entitling it to its retention license in the first instance. But the merits of that contention are belied by its after-the-fact timing. Not once did Tanzania ever suggest that the claimant was not entitled to retention licenses from the time its own ministry granted them in 2014 until these proceedings. The claimant's licenses applications ran over 100 pages, and they appended a further 300-page economic study of the project. They were studied in detail by the personnel of the Commissioner for Mines under the guidance of the now-defunct Mining Advisory Board. Each and every one of those personnel thought that my client did qualify for a retention license, and they duly approved the application. But Tanzania's argument is that the license was invalidly issued is based solely on the opinion of an academic, Mr. Nrumo, who's sitting in this very room. He's a fact witness in these proceedings. Thus, Tanzania would have this tribunal believe that its own Ministry of Minerals got it right. But somehow 8 years later, they got it wrong. But somehow 8 years later, Professor Nruma got it right, and that this tribunal should therefore second-guess the ministry's decision to issue the license. Now that concludes what I'm going to say to you on background of this dispute. But before I pass it over to Ms. Jardine, I do want to make one last point, and that point is about evidence. One of the recurring themes of this case has been the stunning lack of evidence the respondent has adduced, either in support of its own defense or pursuant to this tribunal's orders during the document production process. I'm going to give just one illustrative example. Now, in 2017, a report circulated that President Magufuli had commissioned a so-called investigating committee to investigate compliance issues in the mineral sector. Shortly after that committee handed over its reports to the president on national television, no less, the government promulgated the amending legislation. So, in other words, this investigating committee report could shed light on why Tanzania decided to cancel retention licenses in the first place, which is one of the key issues of dispute here. However, Tanzania has never made that report public, and despite having been invited by the claimant and ordered by the tribunal to produce those reports, it hasn't done so. And here's the kicker. Professor Nruma served as the chair of that committee. The very one who's here to tell you that our license wasn't valid. And yet, he doesn't even mention the investigating committee in either of his witness statements. And not a single document has emerged from that committee, despite his participation, well, now as a party rep of the respondent in these proceedings. And so we remain in the dark, as the claimant has for 6.5 years now, as to what the genesis of Tanzania's decision to write the retention licenses out of existence. Now, doubtless we will explore this lack of paperwork with Professor Nruma later this week, but I'd invite the tribunal to think of this asymmetry of evidence during its deliberations. The claimant has produced 458 factual exhibits to discharge its burden of proof. The respondent has produced just 71 factual exhibits, many of which are duplicative of the very ones we've produced. With its rejoinder, the respondent didn't produce any factual exhibits at all. Where the respondent has refused to produce evidence as ordered, we're requesting that the tribunal make adverse inferences as to what those documents would have revealed. Now, each of those requested inferences is set out in the claimant's reply, but it's also in the demonstrative that we sent to you earlier today. Now, that concludes the introduction to the claimant's opening submissions. All that's left for me to do is explain what you'll hear from the remaining members of our team. First, Mr. Jardine will go back to the beginning of the story and explain the history and the development of the project. Then Mr. Dennison will set out the facts surrounding the claimant's application for a retention license, and Mr. Barrier will explain in detail the measures Tanzania enacted from 2016 onward and the impact on the claimant. He then will explain how those measures breached provisions of the BIT. Finally, Dr. Veit will explain the quantification of the claimant's claim for compensation of 116 million Canadian dollars, plus interest, for the damage it suffered as a result of the respondent's breaches. And in this respect, Dr. Veit will also address some of the issues of disagreement between the claimant's expert, Ms. Vicky Wall, and the respondent's witness, Mr. Mwanga Kala. Those are issues that, of course, will be explored in more detail later this week. Thank you.
Thank you, Mr. Foden. Madam President, members of the Tribunal, we can now turn to the history of the investment at the centre of this dispute, the SMP Gold Project. I will start by addressing Tanzania's investment climate in the mining sector. The parties are, for the most part, in agreement on this point, so I will keep it brief. Should the Tribunal wish to review a fuller explanation, I refer you to Section 2.1.2 of the Claimant's Memorial. It is common ground that Tanzania has a vast mineral endowment. Its particular geological characteristics means that it is rich in various types of minerals, from nickel to diamonds, and importantly for this case, gold. You will see on the screen a map depicting Tanzania's natural resources. Gold deposits are indicated in yellow triangles scattered across the country. Between mid-1990s and 2017, Tanzania also had an attractive investment climate for mining investors. During this time, the state encountered foreign investment heavily, rather encouraged foreign investment heavily, particularly in the mining sector, and attracted large mining companies to commence significant mineral projects, bringing in billions of dollars in foreign investment. It also enacted a modern mining legislative framework, the Mining Act 1998. This act created a stable licensing framework for exploration and mining activities by private investors, removing past discretionary powers of government ministers over licenses. The Mining Act 1998 defined 3 categories of mining rights for the exploration and mining activity: the prospecting license, the retention license, and the mining license or special mining license. When Tanzania repealed the 1999 Act 12 years later with the Mining Act 2010, it maintained this framework almost entirely. We will discuss the mining acts in further detail a little later on. For now, suffice to say, the retention license category was preserved in the Mining Act 2010 and therefore existed for some 19 years before its abolishment. So, if we consider Tanzania when the claimant first invested in the project, it had everything an international mining company would want: strong geological potential, a stable modern regulatory framework for mineral investment, and a government welcoming investors with open arms. Objective standards confirmed this perception. In 2014, the Fraser Institute's renowned annual survey of mining companies, ranking mining jurisdictions based on environmental attractiveness, ranked Tanzania as one of Africa's most attractive jurisdictions. With that background, we can turn to the story of the SMP Gold Project. As Mr. Foden described earlier, the SMP Gold Project concerned the exploration and development of gold deposits in the Lupa Goldfield, located in southwestern Tanzania. Mr. Williams and Mr. Mackenzie are former university colleagues, and it was these two gentlemen who had the idea of the project. But their venture did not start in Tanzania. The pair set up their first company, Bafex Exploration Proprietary Limited, BEL, in Namibia in 2001. After some time, they were looking to expand their operations. Mr. Williams and Mr. Mackenzie therefore started to explore other opportunities to invest in southern African countries, such as Botswana, Uganda, and Tanzania, around 2004-2005. Tanzania stood out among these countries, and there were two main reasons for this. First, Tanzania's favourable investment climate, and its recent history of hosting large mining companies, and second, an attractive legislative framework. In addition, gold prices were booming at the time, and Tanzania had many underexplored potential gold deposits. During a field trip in Tanzania, Mr. Mackenzie noticed an area called the Saza area in the Lupa Goldfield. Whilst there, Mr. Mackenzie met Mr. Mark Stanley, the owner of Thorntree Minerals Limited, TTML, who held a prospecting licence in this area. Following further investigations, Mr. Mackenzie and Mr. Williams decided to invest in this project. So, once submitting a recommendation to the board, which you can see on the screen, and which was accepted by the board, Helio acquired the Saza prospecting licence. Before I move on, I would like to briefly explain the claimant's corporate history and why I just said Helio acquired the Saza prospecting licence and not BEL. As I mentioned, Mr. Williams and Mr. Mackenzie incorporated BEL in Namibia in 2001. Then, in May 2002, Mr. Williams and Mr. Mackenzie incorporated another company, Bafex Holdings Limited, BHL, in the British Virgin Islands. The purpose of BHL was to act as a holding company for BEL and future companies, if and when they expanded the business. BHL became the sole shareholder of BEL. On the 4th of November 2004, BHL completed a reverse takeover of a Toronto Stock Exchange listed company called Helio Capital Corp. The purpose of this operation was to start attracting third-party investments to expand the business. Helio Capital Corp changed its name to Helio Resource Corp as part of that takeover. Helio was the sole shareholder of BHL, meaning the corporate structure through which Helio invested in Namibia looked as per the diagram you can see on the screen. Now, at the time Helio acquired the Saza Gold Project, it did so by incorporating a Tanzanian subsidiary called Bafex Tanzania Limited, BTL. This corporate structure is visualised on the screen. Helio held all but one of the shares in BTL indirectly through BHL, and one share in BTL directly. In January 2020, Helio Resource Corp changed its name to Winshear Gold Corp. This is the last factual event in the claimant's corporate history. So now we've covered the claimant's corporate structure, we can continue with the claimant's acquisition of the project. On the 19th of December 2005, Helio entered into a property option agreement with TTML, which provided the conditions under which Helio and BTL would acquire a 100% interest in the Saza prospecting licence. The claimant fulfilled these conditions and acquired a 100% interest in the Saza prospecting licence on the 23rd of November 2009. In addition to the Saza prospecting licence, Helio acquired 3 further licenses from another Tanzanian company called Dhahabu Resources and Mining Company Limited, all of which were located in the north and east of the Saza prospecting licence, in the Mkongolose area. Upon doing so, the Sasa Makongolossi Gold Project, that is the SMP Gold Project, was born. Over time, Helio furthered its exploration areas beyond the 4 prospecting licenses constituting the SMP Gold Project. But the key deposits it discovered and developed were all within those 4 areas. On the screen, you can see the project area as of March 2015. In the years following its acquisition of the project, the claimant performed drilling programs, surveying, assaying, and metallurgy testing, which led to several discoveries and promising targets, notably at the sites of former abandoned gold mines like the Kagenge, Mabenge, and Porcupine areas. This success attracted international investment by reputable mining investors and funds, such as Macquarie Bank, the IFC, and Scotia. As Mr. Dennison will now explain, all of this work got Helio to the point of achieving a major milestone for any exploration project, its first NI 43-101 technical report.
Thank you, Ms. Jardine. Madam President, members of the Tribunal, I will now explain why and how the claimant came to apply for 4 retention licenses over the SMP Gold Project area. As Ms. Jardine explained, Helio had raised money on the Toronto Stock Exchange and injected those funds into exploration activities at the project. And by 2010, those exploration activities bore fruit in the form of the project's first NI 43-101 mineral resource estimate, which Helio published to the market. NI 43-101 is the name of the Canadian regulation governing reporting of mineral exploration results. And these mineral resource estimates come in the form of lengthy technical documents that run into the hundreds of pages. And because the purpose of these regulations is to protect investors from potentially misleading reporting, NI 43-101 exploration reports are required to be prepared by independent, qualified consultants and according to strict standards. Now this first NI 43-101 report for the project was indeed authored by an independent consultancy, and it estimated the mineral resource for the project of 10,785,000 tonnes of ore, grading 1.43 grams per tonne of gold in the measured and indicated categories, as you can see on screen. And that amounted to just under 500,000 ounces of contained gold. Now, if I can give you a rough idea of the scale of that estimated resource, if you could, hypothetically, of course, dig up and extract all of those 500,000 ounces of gold, it would sell for around $900 million at today's gold prices. After conducting another intense year of exploration in 2011, the claimant reported another NI 43-101 compliant resource estimate in February 2012, this time prepared by the market-leading mining consultancy SRK. And Helio had more than doubled the mineral resource to over 1 million ounces of contained gold, this time at an average grade of 1.32 grams per tonne. And that was just in the measured and indicated categories of mineral resource. Those are the categories with the highest degree of geological confidence. The inferred category contained a further 250,000 ounces. Now, the point I want to get across is this. What the claimant had discovered and done a lot of work defining was a mineral deposit that was potentially of commercial significance. Indeed, if you think about the back of the envelope calculation I just made, potentially commercially significant is clearly an understatement. But I use that phrase, potentially commercially significant, deliberately. And if I may, I would ask you to keep it in mind. Because although it's not a phrase of standard industry or technical definition, it is relevant to the claimant's eligibility for its retention licenses over the project. And as you know, as Mr. Foden explained this morning, Tanzania now claims that the claimant was never entitled to its licenses in the first place. And that's a subject to which I will shortly turn. Now that the claimant had confirmed the geological potential of the project, it conducted a comprehensive economic study to confirm its economic potential. It commissioned SRK again to carry out a preliminary economic assessment, or PEA. And SRK completed that PEA in September 2012, and Helio published it to the market. Now, by way of background, a PEA is typically the first detailed economic analysis of a mineral exploration project to test its economic viability against assumptions other than just the mineral resource itself. And a PEA is often followed by a pre-feasibility and/or feasibility study, which would then cover the technical and financial aspects of the project to prepare for construction of a mine. And the following chart on screen demonstrates the progression, quite simply, from mineral exploration and development stages of mineral projects. However, I want to cast no illusions. The data and technical analysis included in the claimant's PEA were extensive. And based on these analyses, the PEA concluded, and I quote, "Exploration, block model interpretation and study work completed to date, including optimization, mine design and mine scheduling, indicate that the project is potentially economically viable." Now, based on the mine plans it had established, this PEA assessed the project's net present value, and it assessed it to be $85.6 million under a base case scenario. If a 55-degree pit wall could be achieved, which Helio's management was confident it could be, then this PEA estimated the net present value to be $146.1 million, and that was under a so-called upside case mine plan. The gold price assumed in that economic analysis was $1,450 per ounce, and to give you a bit of context, that's $400 below the current gold price. In other words, the claimant had demonstrated the economic viability of the project, assuming, of course, that those economic conditions remained. Unfortunately, however, they did not. From late 2012 onwards, the project was beset by two issues that, whilst temporary, seriously inhibited the claimant's ability to move it to the development stage. The first of those two issues was the gold price. From late 2012 onwards, gold prices dropped and remained low, well below the $1,450 per ounce assumed by the PEA, and they remained low until mid-2019. Now, this drop in gold prices had two impacts. First, Helio needed to reassess the project's economic assumptions to consider its viability in a low gold price environment, and it could do so by increasing the grade of the mineral resource, but only, of course, by conducting further studies. However, and importantly, it also made it much more difficult for the claimant to attract the investment it needed to complete those studies and the further appraisal and development activities it required to be able to apply for a special mining license. The second issue affecting the project from 2012 onwards was interference from illegal miners. In October 2012, BTL's in-country manager, Mike Ashley, reported to the board that a group of illegal miners had confronted and threatened him and a group of potential investors that he was showing around the Saza prospecting license area, claiming that Helio was operating on their license area, despite the fact that upon inspection, their license coordinates revealed that their license was in fact 100 kilometers away. Now, this confrontation escalated over the following months, and the full story is explained in detail in Section 5 of Mr. Mackenzie's first witness statement. But for present purposes, it suffices to note that the claimant sought the assistance of government officials from the local level all the way up to the Commissioner for Minerals himself. Nobody was willing to exert the required authority to prevent these incursions of illegal miners on the project site. As Mr. Mackenzie explained in his witness statements, this issue of illegal miners prevented the claimant from further exploring some of the key deposits, and it made the task of securing further funding from equity investors even more difficult in the already challenging market conditions. So all in all, the illegal miners and the market conditions inhibited the claimant's ability to move the project to the feasibility study stage immediately. Luckily, the Tanzanian legal mining framework catered exactly to that situation by offering a retention license. So I'd like to pause the story of the development of the project for a moment, and if you'll bear with me, I'd like to explain the licensing framework in existence at that time that the claimant applied for a retention license over the gold deposits that it had defined. Now, you'll recall, as Ms. Jardine explained, there were three principal types of mineral right: prospecting license, retention license, and mining license. The prospecting license granted the exclusive right to carry out prospecting operations within the license area during the period of validity of that license. And once an investor was ready to start mining those mineral deposits that they had identified and defined, they would of course need a mining license. A mining license, or special mining license, granted the exclusive right to carry out mining operations within the license area for a specified type of mineral. And the third license category, which is the one at the heart of this dispute, was of course the retention license. Now, a number of jurisdictions with mineral exploration industries include in their framework an intermediate license category between exploration licenses and mining licenses. For example, Australia, Namibia, Pakistan, and South Africa, amongst others, have legal frameworks containing concepts similar to this retention license. But the general idea is the same in each jurisdiction. It's to allow an investor that has discovered a mineral deposit of significance to retain tenure over its project if it cannot yet develop a mine for reasons beyond its control. And Tanzania's Mining Acts 1998 and later 2010 followed this common approach. The retention license category was governed by sections 37 and 38 of the Mining Act 2010. Now, as Mr. Foden explained earlier, it's important to bear those section numbers in mind as when we return to the amendments of the Mining Act that Tanzania later enacted. Section 37.1 of the Mining Act 2010 read as follows, and I quote, "The holder of a prospecting license may apply to the Minister for the grant of a retention license on the grounds that A. He has identified a mineral deposit within the prospecting area which is potentially of commercial significance, and B. The mineral deposit cannot be developed immediately by reason of technical constraints, adverse market conditions, or other economic factors, which are or may be of a temporary character." Those were the only two conditions of eligibility for a retention license. There were some documentary requirements as for the retention license application itself, and those were contained in section 37.2 of the 2010 Act, and I'll return to those shortly. For now, if we look further at sections 38.3 and 38.4, we see that the initial period of a retention license was 5 years, and if at the end of that period commercial development of the deposit was still not possible, the holder had the option to renew the license for a further 5-year period upon application to the Ministry of Minerals. So in total, that gave the holder up to 10 years to get their project to the special mining license stage, reflecting the reality that a depression in mineral prices, or for example, the length of a technical constraint, could last up to 10 years. Now, you might be thinking, 10 years is quite a long time for a license holder to be given exclusive tenure over their project. Well, that brings us to section 38.5 of the Mining Act 2010. The Minister for Minerals had statutory authority to request a retention license holder to explain why it had not yet applied for a special mining license. You already may have deduced the purpose of this provision. In essence, it's a protection against retention license holders simply sitting on land that could be developed. It allows the government to step in and ask, why aren't you getting on with it? And if the retention license holder failed to give an adequate answer, under subsection 38.6, the Minister had the power to require that retention license holder to either apply for a special mining license or surrender the retention license. Now, the retention licenses at the centre of this dispute are retention licenses numbers 9, 10, 11 and 12 of 2014, and you can see them on the screen. We call them the SMP retention licenses. I think what I've described so far about Tanzania's mining legislative framework is actually largely uncontroversial between the parties. However, as I'll explain shortly, unfortunately the respondent has tried in these proceedings effectively to rewrite its own legislation, inserting additional conditions for eligibility for a retention license that are not in the statute and at no point have been placed on any applicants or license holders in the past. And it does so to support a misguided and untimely argument that the claimant was never entitled to these SMP retention licenses in the first place. So I'll now explain how the claimant applied for the SMP retention licenses and why each of those applications fulfilled all relevant conditions. BTL submitted its application for a retention license over the SARSA prospecting license area on the 4th of May 2013. It later submitted applications for retention licenses over the 3 Makongolossi prospecting license areas on the 19th of October 2013. Now, BTL's applications for the SMP retention licenses were quite straightforward. Each of them explained how BTL complied with the requirements of Section 37(1) of the Mining Act 2010. As Mr. Mackenzie explains in his witness statement, BTL did not prepare these applications alone. It engaged a Tanzanian law firm, Rex Attorneys, to assist with the application process. The retention license applications explained that BTL had identified mineral deposits that were potentially of commercial significance, but which could not be developed immediately because of, quote, various factors, including adverse market conditions and technical constraints. And the retention license applications each appended a number of supporting documents, chief among which was the PEA. Now, the PEA is a long and detailed document. It runs to 313 pages, and you'll be pleased to hear, I'm sure, that I do not intend to take you through it all. However, I would just like to give you a sense of the extent of technical analysis included in that study, because it's an important document for reasons that will become apparent. So, for example, the PEA contained detailed mine plans, including pit optimization analyses to determine the size and shape of the open pits, a mine design, mine production analyses, fleet and labour requirements, and so on. It also included a general project infrastructure plan. You can see a map of it on screen, including a proposed site layout for open pit mines at Kenge, Mbenge, and Porcupine. The PEA also set out the requirements with which the project would need to comply with respect to environmental, health, safety, and labour legislation, and the studies that would be required at the feasibility stage. And importantly, the PEA also included the latest mineral resource estimates that SRK had produced and published to the market in February 2012, demonstrating that the project had a measured and indicated resource of over 1 million contained ounces of gold, as I previously explained. BTL's retention license applications in October 2013, the latter 3, went further and explained how BTL had spent 25 million Canadian dollars on exploration costs for the project to date. It also explained how the low prevailing gold price was the primary reason for requiring a retention license, and that it needed to, quote, continue remodeling the resource and add higher grade ore to the deposits in order to improve profitability and conduct a revised feasibility study. That's on screen. I want to make this clear. Tanzania was, or ought to have been, under no illusions whatsoever as to the reasons BTL applied for retention licenses and the work that it intended to conduct under them. And Tanzania was clearly satisfied with those applications, because after taking considerable time to review and consider them, the Minister for Minerals issued all 4 retention licenses on 1st of September 2014. Now, as the tribunal is aware, the respondent has belatedly argued in these proceedings that BTL was never entitled to these licenses after all. And before I turn to those arguments in detail, I want to address one important point. And you heard it from Mr. Foden earlier, but it's worth reiterating. The first time the claimant heard from the respondent that there was any issue with their retention licenses was in the counter memorial in these proceedings. The slide on screen demonstrates just how much time and how many obvious opportunities Tanzania has had to raise an issue with the claimant's retention licenses if it considered there were any. And indeed, as Mr. Foden mentioned, in February 2021, long after these proceedings had started, the respondent belatedly invited the claimant to apply for a special mining license in place of those licenses. And even then it didn't suggest that the claimant ought never to have had their retention licenses in the first place. The respondent's 7 years of silence really says all the tribunal needs to hear about the merits of the position the respondent has decided to take here. Nevertheless, I will now address the respondent's arguments in turn. Now, I've already explained that there were 2 conditions of eligibility for a retention license, and you can see them again on screen. However, the respondent attempts to oppose two additional, unstated conditions. First, the respondent seeks to argue that the Mining Act 2010 required the prospecting licence holder to have completed a feasibility study by the time it applied for a retention licence. And to do so, it relies on the witness statement of Professor Mruma, who, I note, is not a mining law expert or even a lawyer. Second, the respondent seeks to argue that the applicant must have established a proven mineral reserve. Here again, to support this alleged requirement, it relies solely on the witness statement of Professor Mruma. Now, the claimant explained in detail in the reply memorial why that position, both of those positions, are not supported by the Mining Act itself, and why it would make no technical or business sense. And that's at section 3.1.3.1 of the memorial. For present purposes, I'll summarise. As we just saw, the language of the Mining Act 2010 itself does not support Tanzania's position. It only contains two substantive conditions. Neither of those conditions requires completion of a feasibility study. As for the form of the retention licence application, section 37.2 only required the applicant to submit, quote, studies and assessments by appropriate independent experts, unquote. And that could cover a whole range of technical documents, ranging from mineral resource estimates to scoping studies to PEAs and potentially to feasibility studies. Similarly, there's no requirement that the applicant establish a proven mineral reserve in these provisions either. Instead, section 37.1, which we can see on screen, simply requires that the applicant has, and I say it again, identified a mineral deposit which is potentially of commercial significance. Moreover, where the Mining Act 2010 does require submission of a feasibility study, it mentions it expressly. For example, an applicant for a mining licence or special mining licence must submit a feasibility study, as stated expressly under section 49.2d of the Mining Act. And quite rightly so. Requiring such a significant piece of work should not simply be left to implication. A feasibility study is, by its very nature, time-consuming and costly. It's a comprehensive technical and economic study of the selected development option for a mineral project. In other words, it assesses all aspects of a potential project to enable a construction decision. In contrast, the entire purpose of a retention license is for projects that, by definition, cannot be developed immediately because of technical, market, or economic constraints. And of course, to allow the holder to retain their tenure for the duration of those constraints. So from a practical and financial perspective, it would be nonsensical to require a retention license applicant to submit a complete feasibility study. Why and how would an investor finance a feasibility study if it already knew it was unable to develop the project in question? And similarly, the purpose of a mineral reserve, as opposed to a resource, is to delineate the parts of the resource that's economically extractable upon application of technical and economic assumptions or modifying factors. Now, there'd be little point in applying these technical and economic modifying factors to a resource that's not yet exploitable. Establishing a proven reserve before the feasibility stage would be pointless, and in fact might not even be possible precisely because of those technical and economic factors. Now, those arguments were all made in the reply memorial. In its rejoinder, the respondent did not directly address any of them. The respondent's only rebuttal was that the words studies and assessments by appropriate independent experts or consultants acceptable to the minister, that's from section 37.2 of the Mining Act, must mean feasibility study and no less. And its explanation for that assertion was that, quote, Tanzania regulatory mining sector is based on pure spirit of the law, unquote. But the respondent has not submitted any further evidence or legal authority in support of that position. Now, finally, the respondent has also suggested that the claimant misled the authorities by suggesting it had completed a feasibility study within its applications when it had only actually completed a PEA. Now, in an attempt to support that argument, the respondent latches on to BTL's statement in its application that it wanted to continue working on the project, quote, in order to improve profitability and to conduct a revised feasibility study, unquote. But that argument simply does not withhold any scrutiny. because there could be absolutely no doubt, even on a cursory review of BTL's application, that the project was not at a feasibility study stage. The application contained multiple references to, and even attached, the 313-page PEA. Furthermore, in a subsequent letter dated 20th of December 2013, BTL clarified again that what was attached to its application was a preliminary economic assessment, which it said constitutes a scoping study. Mr. Mackenzie explained in his second witness statement that the reference to a revised feasibility study was simply a poor choice of words and that he was indeed referring to the PEA. Now, finally, in its rejoinder, the respondent acknowledged its prior confusion and made the significant admission that, quote, whether you call it a feasibility study or not, the content of it contains a, the extent, prospects of recovery and commercial significance of the mineral deposit and the relevant market conditions, trends, technical and economic factors. B, the impact of mining operations on the recovery of the mineral deposit on the environment and the manner of eliminating or minimizing any adverse effect. So, in other words, the respondent appears to have abandoned its alleged requirement for a feasibility study and has actually fallen back on the plain language of Article 37 of the Mining Act, which is essentially copied and pasted into that section of the rejoinder. So why is this a significant concession? Simply because that language on screen corresponds exactly to a description of the PEA that was attached to the retention license applications. So let's have a quick look at the topics the PEA covered. And I'll just show you some extracts of the contents pages. 14. Mineral resource estimates. 16. Mining methods. 17. Recovery methods. Those ought to cover extent, prospects of recovery, and the commercial significance of the mineral deposit. Then we have 21. Capital and operating costs. 22. Economic analysis. Those ought to cover relevant market conditions, trends, technical and economic factors. And environmental studies, permitting, and social or community impact. That covers impact of mining operations on the recovery of the mineral deposit, on the environment, and the manner of eliminating or minimizing any adverse effect. So the PEA satisfied these documentary requirements. And this is what the Ministry of Minerals must have understood in 2014, because it did not raise any complaint or request any further documents, let alone a feasibility study, before granting the retention licenses. The only possible conclusion is that BTL's applications met all relevant criteria to be granted the retention licenses. And what's more, as the claimant explained in the reply memorial, the publicly available evidence suggests that the respondent took the very same approach with all other retention license applications it granted. Notably, Tanzania's flagship nickel project, Kabanga, did not have a feasibility study when Tanzania granted and later renewed its retention license, and does not, and still does not, have a proven mineral reserve. The claimant has produced a wealth of evidence indicating that no other retention license holders had been required to produce a feasibility study before applying, but the respondent simply has no answer to this evidence. So I leave the tribunal to draw its own conclusions with respect to this issue in light of the respective evidence the parties have provided. Now, the next point on which the parties disagree with respect to the retention license category is what holders were and were not allowed to do under those licenses. In the counter-memorial, the respondent argued that retention licenses do not permit the holder to conduct additional exploration, research, or other appraisal work to demonstrate the viability of mining. But again, its position is not supported by law, by common sense, or by history. Neither Section 37 nor Section 38 of the Mining Act contains any prohibition on further exploration or appraisal during the term of a retention license. Rather, Section 38(3) indicated that if there were to be any restrictions on what could be done vis-à-vis the deposit, the Ministry of Minerals would indicate those conditions in the license itself. And for the avoidance of doubt, of course, the claimant's retention licenses did not contain any such restriction. Under Section 38(4) of the Mining Act 2010, the Ministry of Minerals had the power to request updated studies and assessments from a retention license holder. Of course, this suggests the holder must have been doing something to require an update. Otherwise, there'd simply be nothing to update at all. If retention license holders were required simply to sit on the license area and do nothing, they would not be able to even try to overcome the very technical or economic issues that had prevented them from developing the project in the first place. And after all, how could a retention license holder even know if they had overcome those issues without conducting further studies to assess them? And again, the respondent's position is further undermined by history. Publicly available evidence again shows that former retention license holders, including Kabanga as I mentioned before, continued their exploration work under their retention licenses. And there's absolutely no evidence to suggest that the government complained about any of this conduct at the time, in respect of BTL or any other retention license holder. And indeed, BTL itself continued some exploration work on site and explained as much in quarterly reports submitted to the government under those retention licenses. The Ministry never objected upon receipt of any of those quarterly reports. Again, there's been a suggestion in these proceedings that the claimant somehow misled Tanzania by applying for a retention license when it still intended to conduct exploration under those licenses. And as I already explained, BTL made its intentions to conduct further exploration clear in its applications for those retention licenses. If there were anything untoward about that part of the application, one would have, of course, expected the Ministry to come back and say to BTL that that was not an option. Rather, far from doing so, the Commissioner for Minerals actually wrote to BTL on the 7th of October 2013, that's after the first retention license application went in, stating as follows, and I quote, "We hereby confirm our support for your future exploration and mining activities in our country. We are currently finalising your application for retention license." And as we know, it did grant and finalise and grant the claimant's application. This really ought to be the end of the matter. So, members of the tribunal, that ends what I have to say today, and I think we're just under halfway through our opening submission, so if it's a convenient moment, I think, subject to the rest of my team, I think now is a convenient time to take a break, should it be convenient for the tribunal also.
Apologies. Thank you. I was saying that you have been going for about an hour 15. It's maybe a good time to break if that's convenient to everyone. Let's take 15 minutes now and resume in 15 minutes.
Thank you.
Is everybody ready to resume? Good, you've changed.
Yes, yeah, I have changed. Madam President, just to put it on record, we have Mr. Said Rashid Nyenge, who just joined us as a respondent representative. He's on the list, so...
Yes, I've seen him.
Yes.
Excellent.
So yeah, he's here.
Thank you. Welcome.
Thank you. Otherwise, we are ready to proceed.
Thank you. We're ready to continue listening to the claimant.
Thank you, Madam President.
Mr. Barrier, your turn.
Thank you. Madam President, members of the tribunal, I will now address the sequence of facts under which Tanzania expropriated the claimant's project. I will then establish that these acts constitute breaches of the Canada-Tanzania BIT. But before that, let's look at the project as it was in 2016, before Tanzania began enacting measures which impacted its own mining industry. The claimant was experiencing difficulties obtaining financing as a result of the depressed gold market. To keep the project afloat, it had made sacrifices, including selling its Namibian assets, reduce its management staff, who also had to accept pay cuts. But despite the adverse economic circumstances, the claimant managed to pursue the development of the project under the SMP retention licenses by raising additional funds. With these funds, Helio managed to further improve the project mineral resources and cut-off grade in October 2013 and March 2014. In May 2014, Helio raised another 4 million Canadian dollars in the project. This enabled Helio to initiate a new successful diamond drill program. On the basis of the work accomplished, the claimant requested a mining consultant, Snowden, to update the mineral resource and complete a desktop study meant to pave the way for a future feasibility study. Snowden also prepared a drill plan to further increase the level of confidence in the project's resource and progress towards this feasibility study. In other words, in 2016, the claimant was adapting to the new environment, and the project appeared to follow a new path towards production. And the claimant had time to complete this process. After all, the SMP retention licenses were valid until September 2019, leaving the claimant 3 years to make progress. Furthermore, the claimant knew that it could request and, in all likelihood, obtain a 5-year extension of its licenses. The problem is that Tanzania stopped the project in its course. In 2016, a newly elected president, Mr. Magufuli, launched a populist campaign against foreign mining companies, and in particular Acacia. Now, let me guide you through what happened. Let's rewind for a moment to the genesis of the measures that destroyed the claimant's investment. On 25 October 2015, Tanzania held general elections. Dr. Magufuli, the candidate of the CCM party, which had been ruling Tanzania since its independence in 1961, claimed victory on 29 October 2015. But his opponent rejected his victory, stating that the election had been rigged. He claimed he had won the election with 60% of the votes, 62% of the votes. The opposition also boycotted the inauguration and threatened to hold nationwide demonstrations, as you can see on the slide. President Magufuli was still sworn in, but this had been a close call for him. Under his leadership, the CCM party had almost lost its first election in over 50 years. He thus had to make everyone forget about this controversial election. He thus focused on his most popular promise during his campaign, which was fighting corruption. And as you can imagine, this anti-corruption stance was of course very well received by the investment community at the time. But only a few months after taking his office, President Magufuli's speeches shifted from condemning corruption to blaming foreign investors, and in particular mining companies, for Tanzania's problems. In May 2016, Tanzania began imposing vexatious measures such as tax audits, monitoring of bank accounts, all on foreign mining companies. President Magufuli's own rhetoric made foreign investors begin to question whether they were even welcome in the country anymore. Tanzania also exerted significant pressure on mining companies to process their ore in the country, notwithstanding the fact that it was not economically viable. Soon, the government's attacks concentrated on the largest gold miner in the country, Acacia. And I would like to pause here for a minute, because, as mentioned by Mr. Foden earlier, you will hear a lot about Acacia and its parent company, Barrick, this morning. Our friends opposite will probably tell you that you should not pay attention to what happened to Acacia. They might even reiterate their somewhat bizarre argument at paragraph 158 of their rejoinder that because Barrick and Acacia are not parties to these proceedings, this tribunal should not have jurisdiction to decide on facts pertaining to these companies. The argument is of course absurd, but it shows you how badly the respondent does not want you to look at what happened to Acacia. This is because the evidence strongly suggests that the expropriation of the claimant's projects was collateral damage to the President Magufuli's economic war against Acacia. Now, and to be clear, nothing in the BIT obliges us, the claimant, to establish the motives behind the expropriation of its assets. All he has to prove is that Tanzania expropriated its investment. The reason why we offer this explanation is twofold. First, to date, Tanzania has not offered any explanation to rebut this factual narrative, or any alternative explanation for why it expropriated the retention licenses. Second, Tanzania's harassment of Acacia had a significant impact on the claimant's ability to raise funds for the project. Acacia was a gold mining company. Tanzania's hostility towards Acacia thus had a significant impact on gold mining companies like the claimant operating in Tanzania. Now let's look at the evidence. We have prepared the timeline that you can see on the screen. It shows the main measures taken by Tanzania against Acacia over a period of several months. It starts with President Magufuli's election, and it ends right before the first step in the expropriation of the claimant's project. And what is interesting is that these measures increase in intensity over time. They initially constituted harassment against Acacia alone, with a series of measures aimed at impairing its operations. However, with the ban ordered on the export of unprocessed gold and copper ore in March 2017, towards the end of the timeline, the measures began to affect all mining companies in the country, including exploration companies. The ban indeed made no difference between ore exported abroad for processing and sample and assays transferred out of the country for testing purposes. This measure effectively put a halt to investment in Tanzania pending the resolution of the dispute between the state and Acacia. And this was only a prelude to even more drastic measures, which followed the recommendation made in two reports of an investigating committee, so-called investigating committee, appointed by President Magufuli in June 2017. We have not been able to review these reports. They were never made public. Tanzania did not produce them in these proceedings voluntarily. It refused to comply with the tribunal's order to produce them during document production. There are, however, a few aspects of these reports that transpired in news releases. So what do we know? We know that these reports stated that Acacia had evaded taxes and payments to the state treasury to the tune of 84 billion US dollars since 1998. We also know that the investigating committee recommended that Tanzania drastically change its mining laws to prevent further fraud and abuse. And this is what makes these reports fundamental. They were the sole basis for Tanzania's decision to amend its mining legislation. And the respondent actually does not deny this. Why is that so important? It's because the evidence confirms that these reports targeted almost exclusively Acacia. There is no evidence that these reports mention any wrongdoing or fraud on the part of the claimant or BAFEX or any other former retention license holder for that matter. Now, our friends opposite will probably tell you this afternoon that the investigating committee did not target only Acacia, like they did at paragraph 118 of their rejoinder. However, the evidence suggests the exact opposite. If you look at the slide on the screen, it's a discussion between members of parliament citing to these reports from the investigating committee during the debate of the amending legislation. But as you can see, all these citations refer to allegations of wrongdoing by Acacia. They do not refer to any other mining company. It is also quite telling that, as mentioned by Mr. Foden earlier, immediately after the publicization of the committee's findings, Tanzanian authorities demanded that Acacia pay 190 billion US dollars in alleged unpaid taxes, interest, and penalties a few weeks after these reports. Again, no other company was targeted by Tanzanian tax authorities. In other words, Tanzania amended its legislation on the basis of the recommendation of reports which targeted one company. Whether Acacia committed the wrongdoings it was accused of is completely irrelevant to this case. What matters is that the claimant and BAFEX have never been accused of any tax fraud or any other wrongdoing. They never faced any accusation similar to those leveled against Acacia. Yet, they fell prey all the same to a change of legislation, the only purpose of which was to address the balance of the state's relationship with Acacia. I will soon provide the details of this new legislation, but before, let's pause to consider the claimant's situation towards the end of the second quarter of 2017. First, as explained by Mr. Williams in his witness statement, Tanzania's hostility against foreign investors had made it almost impossible for the claimant to attract investment anymore. Mr. Williams explained in his first witness statement that Tanzania's attractiveness as an investment destination plummeted, and he prepared this graph that you see on the screen, which shows the country's decrease in attractiveness based on its rankings in a specialized publication. The same publication recorded the deterioration of the investment climate, notably due to the miners', and I quote, increased concern over uncertainty regarding the administration, interpretation, or enforcement of existing regulations. Second, President Magufuli's multiple statements that artisanal miners should take what was rightfully theirs encouraged illegal miners, which resumed their activities at the project site, making it even more difficult for the claimant to progress the project and find investors. After nearly a year in inactivity, illegal miners had indeed begun in 2016 to operate within BTL's license areas. And instead of acting on this, Tanzanian authorities demanded that the claimant pay them off, that the claimant pay off the illegal miners. Likewise, in January 2017, the main group of illegal miners, the so-called TJ group, again began activities within the license area, preventing BTL from conducting any work there. The district commissioner's only reaction to that was that, quote, there will be no work in the area until TJ money is paid, as Mr. Stanley reported to Mr. Williams. In other words, not only did the government's measure prevent the claimant from advancing the project, they also indirectly damaged it further. Thus, unless it could find a way to fast-track development, the claimant would eventually have had no other option but to request an extension of its retention licenses, as other mining companies had successfully done before. In this bleak context, when the holder of a mining license neighboring the SMP Gold project, Shanta Gold, approached the claimant with a merger proposal, the claimant decided to hear them out. It is quite likely, actually, that Shanta had waited for this exact moment when the claimant was the most vulnerable to make this move. Mr. Williams testified that the negotiation was fairly one-sided. It resulted in an agreement under which the claimant's shareholders would be entitled to a little less than 10% of the combined entity's shares in an all-share transaction. Mr. Williams testified that the board of ILIO did not consider this offer as reflective of the true value of the company at the time. As highlighted by the advisor hired by ILIO to provide a fairness opinion on the contemplated transaction, the potential upside of the deal existed, but it was only significant in the medium to long term. As you can see on the screen, the advisor noted that the significant increase in value that would result from the synergies and accumulated resources of the two companies would occur in the future, not at the time of the transaction. In any case, the contemplated transaction itself was not in any way final. It remained subject to the claimant's shareholders' approval, as well as a number of other regulatory approvals and authorizations. The shareholders' meeting was supposed to reach a decision on the transaction in late August 2017. However, Tanzania did not give them the time to make this decision. 3 months after the issuance of the investigating committee's reports, Tanzania amended its mining framework significantly. It did so through a rushed procedure which only had the bare appearance of legality. On 28 June 2017, Tanzania published 3 draft bills. Now, we are more than 2 years into these proceedings, and we do not know much about these draft bills. We do not know who prepared them. We do not know when they were prepared and for what purpose. They appeared out of nowhere, without any prior consultation or advance notice. The claimant made a series of document production requests to answer these questions. The tribunal granted them, but Tanzania refused to produce any documents. We are thus left with the implications of such a refusal. First, the draft bills were prepared in secrecy and behind closed doors. And second, they were prepared solely by government representatives without conducting any impact or risk assessment study and without consulting any relevant stakeholder from the mining sector, let alone any retention license holder. These draft bills constituted a fundamental change to Tanzania's mining framework. Mr. Foden described the most salient measures of these acts in his introduction. For my part, I will focus only on the last of these three draft bills, the one that would eventually become the 2017 Act, and it contained significant amendments to the Mining Act 2010. We summarize them on the slide that is on the screen. So the draft bills provided for the immediate and automatic allocation to the state of a 16% free carried interest in all mining projects. Concretely, this means that the state instantly gained a 16% interest in any mining project without having to make any contribution whatsoever. It also provided for a significant increase in royalty rates on metallic minerals, including gold, from 4 to 6%, and this was to be added to a newly introduced 1% clearing fee and an undetermined inspection fee. Now, you must understand that these royalties are a significant source of costs for mining projects. A drastic increase in royalties can significantly affect the profitability of the project going forward. The draft bill also imposed local content requirements, forcing mineral rights holders to give preference to goods and services procured in Tanzania, notwithstanding the country's inability to provide those goods and services. It finally included an obligation for mining companies to submit to the General Geological Survey of Tanzania all the geological data relating to their project. However, if you look at this slide, there is one thing you will not see. This slide does not mention any measure relating to the retention license category. And this is not an oversight on our part. This is because as of 28 June 2017, the retention license category was still part and parcel of the legislation. It was left almost untouched, subject only to minor tweaks. However, this changed radically during the process of enactment of the amending legislation. Our friends opposite will tell you this afternoon, no doubt, that the enactment of the draft bills followed the process in accordance with due process, fair and transparent. But it is quite difficult to accept this position. The typical Tanzanian legislative process for enactment of draft bills usually takes months, if not years. Here, the whole process lasted only 7 days. This slide compares the consultation process that resulted in the legislative enactment of the Mining Acts 1998 and 2010 in the first and second timeline, and the very small part at the bottom, the legislative process that resulted in the July 2017 amending legislation. Now, you see it took 5 and 7 years, respectively, of intense and open consultation and contribution to arrive at mineral policies in 1997 and 2009. Then, on the basis of these mineral policies, Tanzania has issued Mining Acts 1998 and 2010 after another year. If you look at the part preceding the enactment of the amending legislation in 2017, you see that there is essentially nothing. The draft bills came out of the blue without prior consultation, without prior work being done. The resulting legislative process occurred at an unusual speed. It took exactly 7 days. Only 7 days during which the mining sector discovered new legislation that would be significantly altering the mining framework without much of a chance for them to comment or contribute to it. Tanzania introduced the draft bills under an emergency procedure, even though there was plainly no emergency to address at the time. Even then, Tanzania did not even properly follow its own emergency procedure, and you can read much more about that at paragraphs 228 and 231 of our reply for the record. More importantly, we are still to hear from our friends opposite why it was so urgent to vote these bills in such a rush and essentially hide them from the public. We have a theory on that, but we'll come back to that later. The government published the draft bills on Wednesday, 28 June, as you can see on the calendar on the screen. The next day, Thursday, 29 June 2017, the Parliament invited stakeholders to provide their opinions. The stakeholders had until Saturday, 1st of July, to provide their opinion. Sunday was a parliamentary recess. The parliamentary session started on Monday, 3rd of July, and ended on Wednesday, 5th of July, with the vote 7 days, including a Sunday, so only 6 working days. As you can see on the screen, the Parliament invited stakeholders to comment on the bill by or on Saturday, 1st of July 2017. The invitation is from the Parliament. Stakeholders thus only had like 1 working day to submit contributions. And this raises the question, how is a stakeholder meant to review hundreds of pages of legislation and make any meaningful contribution during the course of just 1 working day? And the answer is obviously they were not. Now, Tanzania will tell you that stakeholders were able to participate in the process. They will do so by referencing 1 single letter from the Tanzanian Chamber for Minerals and Energy, dated the 1st of July 2017. Let's look at this letter. You have it on the screen. The TCME was actually highly critical of the speed and of the consultation process. In its view, the process was done, quote, hurriedly and without due consultation. The TCME also highlighted the stark contrast between this hurried process and the extensive consultation which preceded the enactment of the Mining Act 2010. So all we have on record is only 1 contribution from the public. Our friends opposite have indeed refused to produce any other contribution from stakeholders, despite an order from your tribunal to do so. And what is this only contribution about? It is to criticize the lack of public consultation on such an important matter. And it also contains a severe criticism of the substance of these draft bills. Members of Parliament from the opposition also considered that the lack of consultation for such an important legislation was an issue. You can see that on the screen as part of the discussions. Finally, and we cannot stress this enough, the TCME and the other stakeholders could only comment on the draft bills as they stood on 28 June 2017. And as mentioned earlier, this version of the draft bills did not include the repeal of the retention license category. You see on the screen what was in the draft bill. On 28 June 2017, it only included amendments to sections 37 and 38 of the Mining Act 2010. No deletion. These amendments were inconsequential. They merely consisted of additions for consistency with the rest of the Act. What is important to bear in mind then is that on 28 June 2017 and until the 4th of July 2017, the claimants' licenses were not at risk. Retention licenses were still part of Tanzanian legislation. However, this changed in the course of just 1 week. On the 4th of July 2017, during the second reading of the draft bills, Tanzania suddenly repealed sections 37 and 38 through a last-minute surprise amendment. You see this amendment on the screen. As Mr. Foden mentioned, repealing sections 37 and 38 of the Mining Act 2010 means writing this entire license category out of existence. The Parliament voted the draft bills, including this amendment, on the 5th of July 2017, a week after the government had made them public. All of this in 7 days. Again, there was no sense of emergency, no threat to national defense, no natural disaster, nothing warranting the use of an emergency procedure. So why the rush? Well, President Magufuli told us why. As you can see on the screen, he explained candidly that he had decided to, quote, rush through the bills because the country was in the midst of an economic war, unquote. So President Magufuli needed these measures as weapons in his war against foreign investors. And these weapons hit their target. A few days after the entry into force of the amending legislation, Acacia entered into negotiations with the state. Now the sequence is pretty clear. The amending legislation was meant to force Acacia and other producing mining companies like AngloGold Ashanti to engage in negotiations. This sequence also sheds light on the rationale behind the 11th hour amendment of the draft bill on 4th of July 2017 to remove the legislative basis for retention licenses. And this is because, like, who is the author of the 4th of July 2017 amendments? As you see on the screen, it was Professor Kabudi. Interestingly, Professor Kabudi was, at the time, the head of the negotiation team appointed by President Magufuli to negotiate with Acacia. Again, anything irregular in this case seems to tie back to the government's measures against Acacia. And why did Professor Kabudi decide to repeal the legislative basis for retention licenses? Well, as you can see on the slide, Barrick, Acacia's mother company, operated the Kabanga nickel project in a joint venture with Glencore. And how did they hold this project? Well, under retention license. The government must make sure that no aspects of Barrick's operations in Tanzania, including its own operations or its subsidiary, Acacia, would remain unaffected before the beginning of negotiations. The problem is that it also effectively expropriated all retention license holders, including the claimant, by the same token. And in fact, this had an immediate impact on the claimant. Shanta relied on the amending legislation to cancel the contemplated merger agreement reached in June 2017. Shanta did so on 17 August 2017, before Ilios shareholders could approve the transaction. Our friends opposite may say, as they have in their rejoinder, that Shanta's decision was not prompted by Tanzania's measures. Well, the first paragraph of Shanta's letter that you see on the screen addresses this objection better than I could. Tanzania also insists that the claimant did not accept Shanta's decision and rejected it, threatening Shanta of legal proceedings. And this is true. But this is simply because the claimant at the time did not know that its retention licenses would be expropriated through the 2018 regulations. After all, in September 2017, Tanzania accepted the payment of the claimant's fee for all 4 of its licenses, suggesting that they were in good standing. In other words, Tanzania took the claimant's money for licenses that it would nationalize just a few months later, as I will now explain. Until January 2018, the claimant remained unsure whether Tanzania's repeal of the retention license category affected its own licenses. But the claimant's hopes were dashed when the government issued the decrees implementing the amending legislation, and in particular Regulation 21 of the 2018 regulations made it clear that all existing retention licenses would cease to exist and that the underlying areas would be returned to the state. Mr. Foden has already introduced you to this provision earlier. You see it again on the screen. Now, notwithstanding the wording of the 2018 regulations, Tanzania kept stringing the claimant along. For 2 years, it told them that it would come up with a solution to preserve its rights. After Tanzania issued the 2018 regulations, BTL wrote to the Minister of Minerals to inquire about the treatment of the SMP retention licenses. BTL also suggested that a viable alternative solution would be for the ministry to issue a new license, a prospecting license. The ministry did not respond to this letter, but the claimant's representatives eventually met with the Deputy Minister Biteko during a site visit he made in the Songwe region. Following up on this meeting on 12 March 2018, BTL wrote to the Deputy Minister Biteko proposing a number of steps to advance the project, the first of which being that the retention licenses be reissued as prospecting licenses. On the 2nd of May 2018, BTL met again with Deputy Minister Biteko in Dodoma this time. And during this meeting, the Deputy Minister was very supportive of the project and indicated that Tanzania had no intention of expropriating it. He further made proposals to advance the projects and suggesting in particular that BTL should apply for a prospecting license as replacement for its defunct retention licenses. BTL thus applied directly to the Ministry of Minerals for a prospecting license on the 15 May 2018, but he did not receive response. However, whenever BTL engaged with officials, Tanzanian officials after that from the Ministry of Minerals, it was reassured that there was a process in place at the ministry as level to deal with the issue and that BTL would receive an alternative title. On the 20th of November 2019, Helio finally received a direct update from the Ministry of Minerals indicating that the government was, quote, preparing a framework procedure for issuance of licenses in areas formerly covered by retention licenses. In light of the positive feedback received so far from the Ministry of Minerals, Helio was optimistic that the upcoming procedure would result in BTL being given back some form of tenure over their retention license areas. But only a few days after this letter, the claimant came to realize that it had been misled. On 19 December 2019, the Mining Commission published a, quote, request for pre-qualification for joint development of reverted areas under formerly retention licenses, unquote, which included the SMP retention license areas. We call it the invitation to tender. The Mining Commission addressed the invitation to, quote, eligible companies with technical and financial records in the mining sector. This is paragraph 3 of the invitation. It was not limited to previous retention license holders. The deadline for the submission of the bid was 16 January 2020, less than a month after its issuance. Yet again, Tanzania was apparently in a rush for reasons that remain unknown to the claimant. The invitation to tender offered to pre-qualified a successful bidder for a joint venture with a state mining company, Stamico. Stamico was to hold 20 to 30% of the shareholding in the project, while the state would hold an additional 16% free carried interest in accordance with the amending legislation. So Tanzania would thus keep for itself 36 to 46% of the project without having to make any capital contribution. Applicants were also required to commit to reallocate portions of the former retention license areas to small-scale miners. But most notably, as you can see on the screen, the invitation to tender included the requirement that the successful bidder, quote, commit to compensate previous license holder for the exploration costs incurred, unquote. Now, as Mr. Foden mentioned earlier, Tanzania appeared to acknowledge that it had committed an expropriation and accept that the claimant was due some form of compensation, albeit from third parties. However, the very next day, the Mining Commission issued a revised invitation to tender. It was identical to the first one, except that it removed this compensation requirement. When the claimant realized that Tanzania had put their license out to public tender, and that if it submitted a bid, it would just be one among many bidders for its mineral deposits, it notified Tanzania of the existence of a dispute in accordance with the BIT. Now, in January 2021, shortly before the notice of intent, the claimant changed its name from Helio to Winshear. The claimant informed Tanzania of the same through the notice of intent. Now, the respondent cannot allege today that he was unaware of this change of name or that this change may have any jurisdictional consequences. I will now focus on why the facts before this tribunal constitute an expropriation in breach of Article 10 of the Canada-Tanzania BIT. We will then touch briefly on how Tanzania also breached the fair and equitable treatment of the standard of Article 6.1 of the BIT. There is no doubt that Tanzania expropriated the claimant's investment. This expropriation was also unlawful under Article 10 of the treaty. The test for expropriation under Article 10 is that there must be a substantial deprivation of the claimant's investment, that this deprivation be of a permanent nature, and that it be without justification under the police powers doctrine. Tanzania substantially deprived the claimant of its assets in 3 steps. Mr. Foden already showed you this slide this morning, but essentially Tanzania repealed sections 37 and 38 of the Mining Act, the legislative basis for retention licenses, through the amending legislation as a first step. Second step was that Tanzania cancelled all pre-existing retention licenses, including the claimant's retention licenses, and reverted the areas granted under those retention licenses to the state under Regulation 21 of the 2018 regulations. And finally, the first step is that Tanzania offered the areas previously held under the claimant's retention licenses to international public tender, as we just discussed in December 2019. It did so without offering the claimant any compensation, going so far as withdrawing its previous requirement that successful bidder compensate the claimant. The claimant lost its title to the project. It had been developing for 12 years. The funds it had invested in the project over this period are also lost. The substantial deprivation of the claimant's investment by Tanzania is established on this record. The respondents' argument to the contrary are without merit, as I will now explain. Our friends opposite will tell you that the deprivation was not substantial and permanent. This is allegedly because the claimant retains control over the geological data and the core samples produced after years of drilling campaigns and studies over the project site. And this is wrong. Let me tell you why. And I must insist, the core and geological data are valueless without a title over the project area. And to explain that, maybe a metaphor would be in order. Tanzania is essentially telling you, well, yes, we stole your car, but we did not commit any crime because you still own the user's manual for that car. Well, what are you going to do with the user's manual if you no longer have the car? The manual becomes valueless as soon as the car is stolen, just like the core and data are valueless without tenure over the project area. The respondent will also tell you that deprivation was not permanent, and they will rely for this proposition on this letter of 17 February 2021 that you have seen earlier. In this letter, Tanzania invited the claimant to apply for a special mining license. Mr. Foden explained to you this morning why this argument is without merit. Our friends may also tell you that the claimant has not left the former retention license areas and is still operating on the site. Frankly, we do not know where this suggestion comes from. However, Mr. Williams is here, and he can confirm to the tribunal that the claimant does not have any ongoing operations at the site in Tanzania. Finally, Tanzania may argue that the expropriation is not permanent or irreversible because it did not grant licenses over the areas previously held by the claimant to a third party. But under international law, whether Tanzania did so or not is completely irrelevant. What matters is whether Tanzania took the claimant's investment. What Tanzania does with it is of no concern to this tribunal. In any event, the claimant established that mining operations are currently taking place over the SMP retention license areas. The respondent denies the existence of this mining activity in its rejoinder. And this argument is pretty difficult to sustain because, as you can see on the screen, the ongoing mining operations at the project site are visible from outer space. And before we hear any objection, all these pictures come from Google Earth. Anyone in this room can plot these coordinates and compare them with satellite pictures of the same locations from previous years. And if you do that now, you will actually see that mining operations have even progressed and intensified. What is going on at the project at the moment is public knowledge. Is the respondent involved in any capacity in this mining operation? It is not clear, and we are not saying it is. There is simply no evidence for that at this stage. But it's quite difficult to imagine that Tanzania would ignore the existence of operations of that scale. What is clear is that these mining operations have a significant impact on the project resources, and Mr. Williams can provide the tribunal more details on how these mining operations progressed and their impact later today or tomorrow. The respondents also argued that the tender process initiated in December 2019 could not be an expropriation because it was postponed. But whether the Mining Commission postponed the tender is not established on this record. It is also irrelevant to whether Tanzania expropriated the project. Finally, the respondent argues that the expropriation of the project was justified under the police powers doctrine. However, and with respect, this results from a misunderstanding by the respondent of what the police powers doctrine is. There are only two situations that justify an exemption from compensation under this international law doctrine. These principles were summarized by the tribunal in the Magyar farming versus Hungary case, and you see them on the screen summarized. The first justification is when police powers, quote, aim at enforcing regulations against the investors' own wrongdoings. But contrary to what it did to Acacia, Tanzania never alleged any wrongdoing on the part of the claimant before these proceedings, let alone one that could justify the cancellation of their retention licenses. What is more, Tanzania cancelled all retention licenses, not just the claimants, and it has not alleged any wrongdoing on the part of all the other former retention license holders. The second justification consists of, quote, regulatory measures aimed at abating threats that the investors' activities may pose to public health, environment, or public order, unquote. Here again, Tanzania has never even attempted to justify the cancellation of the claimant's retention licenses by referring to any of such grounds. It has never explained why this cancellation was necessary, let alone to achieve a specific public welfare objective, nor has Tanzania even invoked a specific public purpose in this case. Tanzania cannot be exempted from paying the claimant compensation under the police powers doctrine. In accordance with Article 10 of the BIT, to be lawful, an expropriation must be for a purpose which is in the public interest, conducted in accordance with due process of law, non-discriminatory, and followed by prompt, adequate, and effective compensation. It is common ground between the parties that failure to meet one of these requirements makes the expropriation unlawful. Now, taking these requirements in turn, public interest is not what guided the expropriation of the claimant's project. 2 years into this case, Tanzania has failed to utter anything else than vague slogans. It only declared that it took these measures for the benefit of Tanzania or for a win-win situation between the state and investors. However, it has been incapable of explaining why. And this is not sufficient to establish a public purpose. And in the words of the tribunal in ADC versus Hungary that you have on the screen, public interest requires some genuine interest of the public. If mere reference to public interest can magically put such interest into existence and therefore satisfy this requirement, then this requirement would be rendered meaningless, since the tribunal can imagine no situation where this requirement would not have been met. In this case, we have not seen any studies, any reports, data, or statistics suggesting that the repeal of the retention license category would be in the public interest. Likewise, there is no evidence showing that the cancellation of the claimant's retention licenses specifically brought anything positive to the Tanzanian people. Quite the opposite, actually. The expropriation of the claimant's rights was also not conducted under due process of law. And I refer you here to my earlier submissions regarding the numerous irregularities in the preparation and enactment of the amending legislation, as well as the other measures that followed. The expropriation of the claimant's investment was actually the opposite of due process. And the respondent itself admits in its rejoinder that the final measure that completed the expropriation, the invitation to tender, was in fact illegal because it had not been advertised properly. As Mr. Foden explained earlier, this admission confirms that Tanzania expropriated the claimant's project in breach of due process. Now, the expropriation of the claimant's retention licenses was also discriminatory. the amending legislation specifically targeted foreign mining companies. And with respect to retention licenses, out of 8 former retention license holders, 7 were foreign mining companies. What is more, the only Tanzanian company of this list appears to have reached a settlement with the state. The claimant requested the production of the settlement agreement in document production. Tanzania did not deny that this document exists, but it failed to produce it. We invite you to infer from this failure that precious metals, the previous retention license, Tanzanian previous retention license holder, benefited from a preferential treatment, thus completing the discriminatory character of the expropriation. Finally, we have already established that the expropriation of the claimant's rights was not followed by any compensation, let alone a prompt, adequate, or effective one. I will not belabor that point, even though it is worth noting again that Tanzania admitted in its first invitation to tender that compensation was due. Tanzania's treatment of the claimant and its investment was also in breach of Article 6.1 of the BIT. Tanzania does not fundamentally disagree that its behavior breached the fair and equitable treatment standard. Instead, it attempts to shield itself behind an alleged right to regulate and amend its loan legislation. But this is a false debate. The claimant never expected that the mining framework in Tanzania would remain the same. The claimant does not take issue with the respondent's right under international law to amend its legislation as it sees fit. The issue before this tribunal is much simpler. It is whether Tanzania's drastic alteration of its regulatory framework was, in the words of the tribunals in El Paso versus Argentina and Philip Morris versus Uruguay that you see on the screen, quote, adopted outside the acceptable margin of change, unquote. And the answer to this question is clearly yes. The state's decision to introduce a 16% free carried interest increased dramatically the royalty rates for a number of minerals, or implement impracticable local content requirements, essentially created an entirely new mining framework. These were not mundane changes that you can take overnight without prior notice or consultation. They are not simple amendment of existing legislation. Likewise, the retention license category was a stable component of Tanzania's mining framework for 19 years, as we already had the chance to tell you. This mineral right existed and still exists in other countries, like in Namibia, but also, as you can see from Respondents Exhibit R7, it's in Kenya and Uganda, and in many other jurisdictions, without any wrinkles. Nothing in the record suggests that the government, scholars, or any other stakeholders ever voiced any criticisms concerning this license category. None of the reports that the respondent has produced addressing Tanzanian mining legislation at the time contain the slightest concern regarding retention licenses. Nothing suggests that a change to the retention license category, let alone its repeal, was justified. This measure and the subsequent cancellation of all retention licenses through the 2018 regulations was thus an unexpected and upending regulatory alteration clearly outside the acceptable margin of change. And in fact, Tanzania itself set what was this acceptable margin of change. The slide on the screen shows you the process by which Tanzania amended its legislation in 1998 and 2010. And as you can see, it took years, the work of multiple committees and independent studies to elaborate mining policies in the first place, which in turn served as the basis to amend Tanzania's legislation. There was nothing of the sort for the 2017 amending legislation. I refer the tribunal to Exhibit R3, which is the report of one of the committees that participated in the preparation of the Mineral Policy 2009, the Bomeni Committee that you can see on the screen. The tribunal will see the extent of consultation conducted by this committee, in particular in the mining sector. There is an entire chapter, Chapter 3, which starts from page 31 onwards, which is dedicated to compiling the views of all relevant stakeholders on the mining regime in place at the time. And that resulted in the Mining Act 2010. Again, nothing of the sort in 2017. There was only a secretive investigating committee working behind closed doors, the reports of which were handed to the president on national television, but since then have not seen the light of day. Well, there would be more to say about Tanzania's conduct. Suffice it for today to recall that the respondents' highest representatives, including Tanzania's current president, when looking back on the various regulatory changes from the late President Magufuli's era, admitted that the state had acted unpredictably and inconsistently. This concludes our sections concerning Tanzania's breaches of the Canada-Tanzania BIT. I will now leave the floor to Dr. Mark Veit, who will discuss the compensation the claimant is entitled to as a result of those breaches. Thank you very much for your attention. Do you have any questions?
There we go. Thank you, Mr. Barrier. I have two questions to clarify just what the issues are before us. You started talking about expropriation. Help me please understand exactly what assets of the claimant were expropriated. I understand the theory concerning the canceled retention license. What other assets were expropriated? Assets one can tangible, intangible assets that one can think of as property. What else was expropriated?
Well, essentially by cancelling the retention license, licenses the claimant was holding over the project, the state cancelled the project itself, because without this tenure over the project area, all the work that had been going into the project, all the rights that had been acquired to eventually apply for special mining licenses, all this was expropriated at the same time. So it was really the project itself through the retention license that was expropriated.
All right, with respect to fair and equitable treatment, I understand you listed some measures from the 2017 legislation. I just want to make sure that I have the ones that, in claimant's view, violated the fair and equitable treatment obligation. In addition to canceling the retention license category and canceling the existing retention license. In addition to that, the 16% carried interest requirement was a violation in claimant's view. Is that right?
That's correct, even though it did not affect the claimant directly because it did not have an operating mine at the time. But it impacted the perspective of future development.
The increase in the royalty rate, that also was...
It is also about a breach in our view.
Now, explain to me how those changes, and there are others, the local content requirement, et cetera, how those changes affected, assuming they are violations of fair and equitable treatment, explain how those affected claimant.
Essentially, these measures, there are two issues with the amending legislation. There's one of process and there's one of substance. The process by which it's been adopted basically was the opposite of due process, and it resonated as a...
But that goes to whether it was a denial of FET. I mean, what was the effect of this assumed denial of fair and equitable treatment on
okay, I understand. The effect was on the claimant's prospectivity to some extent. It was about the perspective of developing the project into a mine at a later stage. It was also the possibility to attract financing for future development of the project.
All right, that's helpful. Thank you.
Would you like to continue?
Sure. Thank you, Madam President. Now, as indicated, I'm going to address quantum as the final part of the claimant's opening. And, you know, in the quantum, we are typically discussing but-for scenarios. And in the but-for world, the mine would have been built. and it would have been built and it would have been impacted if it could have been built with the 16% free carried interest and increased royalties. It would have been significantly less profitable. Maybe that goes also to your question. But now, as my colleagues have explained earlier, the S&P Gold project had massive potential. There's little doubt, but for the respondents' actions, that the project would have become a commercial success. And you only have to look at the current operation on site. However, before we address the valuation methodologies in detail, I think it is important to address the standard of damages that we are trying to calculate here. Gladly, the parties are in agreement on this. It is common ground that if the tribunal finds that the claimant is entitled to compensation, that the compensation should be fair market value of the project at the valuation date. Now, the parties differ significantly in their calculations of that fair market value. The claimant values the project at its valuation date at 116 million Canadian dollars. As for the respondent, well, unfortunately, we are not 100% sure what its valuation is. Seemingly in error, the respondent initially put forward two contradictory figures, some $9.5 million and $5.7 million. In its rejoinder, the respondent appears to confirm that the 5.7 million figure was its valuation, but it did not adjust it after it changed its valuation date. So maybe we'll receive some clarification on their position this afternoon. Whatever the respondent's valuation is, however, there is considerable difference between the parties. The main difference arises from the parties' distinct valuation methods. The claimant uses the cost approach in accordance with international valuation and mining industry guidance for assessing the value of exploration stage mining projects. It does so relying on the independent expert opinion of Ms. Vicky Wall, an independent expert with some 25 years of experience in forensic accounting and with experience in valuing assets in the mining sector. By contrast, the respondents adopts a so-called share transaction method, which it then calls adjusted. It does so relying on the testimony of its quantum witness, Mr. Mwangakala. Mr. Mwangakala is not an independent expert. He's a civil servant and has been for the last 14 years. He has also been a party representative for the respondent until yesterday. Whichever way this tribunal intends to deal with Mr. Mwangakala's testimony, it cannot be given any weight as expert opinion. So let me make that clear at the outset. The respondent has not presented any independent expert evidence in support of his choice of valuation approach or the damages calculation thereunder. I would now like to spend some time discussing the parties' differing valuation approaches. In particular, I will explain Ms. Wall's cost approach, how that is an intellectually coherent approach from an economic perspective to arrive at a reasonable estimate of fair market value. Then I will address Mr. Mwangakala's adjusted share transaction approach and explain how this is inappropriate and methodologically flawed. Before I do so, I would briefly cover the issue of valuation dates. The valuation date will naturally flow from your decision on breach. Article 10.2 of the treaty provides that the proper date for assessing compensation for a lawful expropriation would be immediately before the expropriation took place. So now the parties disagree on what the correct valuation date is. We have put forward a valuation date of 18 December 2019. That is the day before the respondent finally confirmed that it would not provide the claimant an alternative license for the project. Hence, this is the day the claimant learned its project had finally been expropriated. In contrast, the respondent, since the rejoinder, argues that the valuation date is the date the 2018 regulation entered into force, hence 10 January 2018. This is not only in contrast with the claimant's valuation date, but also the respondent's counter-memorial and Mr. Mangakala's witness statement, where a valuation date of 10 July 2018 was adopted. Now, the respondent seems to say that this was a slip of the pen in its rejoinder, but curiously, it has not updated its calculation to reflect its correction of the valuation date. The claimant has, however, provided a damages calculation on both its own valuation date and the alternative date earlier that is argued by the respondent. Since the claimant calculates the value of the project by reference to historical costs, mostly predating both valuation dates, the impact on total compensation is really not overly significant. It results in a slightly lower fair market value, as it reduces the return Ms. Wall would have included within the damages by 18 months, but correspondingly adds some 18 months more in pre-award interest. So overall, the result is a slightly lower amount of compensation of about 11 million Canadian dollars. We do consider that the 18 December 2019 is the legally correct and therefore the date that you as the tribunal should follow. So now I will turn to the valuation approach to be adopted in this case. You will no doubt be familiar with the three main valuation methods: the income approach or DCF approach, the market approach, and the cost approach. Choosing a valuation method is an issue on which the tribunal will be assisted by expert evidence. Ms. Wall considers that the most appropriate valuation method is the cost approach. The economic theory behind the cost approach is to estimate value by using historical costs incurred on a project as a proxy for current value with appropriate adjustments. The cost approach requires the valuer to look at all the relevant costs that would be incurred by a third party as if it were developing the project from scratch. Therefore, Ms. Wall included all costs that the claimant incurred in developing the SMP gold project, including exploration costs and non-exploration expenses attributable to the project. The historical costs are relevant because they are part of the valuation exercise to determine the fair market value of the project. To be clear, the claimant is not claiming historical costs. This is not a claim for restitution. It is a claim for compensation, and the parties agree that the standard of compensation is the fair market value of the project. Now, in addition to historical costs, Ms. Wall also includes in her calculation an allocation for a reasonable return Winshear would have expected on those expenditures. I will discuss this aspect of valuation shortly, but again, it's worth making clear at the outset. The claimant is not claiming a return on investment. A hypothetical return is simply another element of the cost approach to calculate the fair market value of the project. Now, the way the cost approach works is by calculating the current replacement or reproduction costs of an asset. The definition you see on the screen is from the International Valuation Standards. The IVS serve as a key guide for valuation professionals globally, and their purpose is to promote consistency, transparency, and confidence in valuations. So one simply adds up all the costs that would be incurred by someone attempting to recreate the asset in question. The IVS explained the application of this theory in section 70.10. And I'll take you through it. So the cost approach should capture all the costs that would be incurred by a typical participant. And such costs include direct costs, but also indirect costs such as overheads and, as you see in item 8, a profit margin or entrepreneurial profit to the creator of the asset, a return to investors. Now, the respondent's own quantum witness expressly endorses the quotation I just read as the correct approach to applying the cost approach. How does one work out the costs that would be incurred by a typical participant trying to recreate the project? Well, the most straightforward way is to look at historical costs that were incurred to date as the starting point, and this is exactly what Ms. Wall does. Ms. Wall calculates the claimant's historical costs attributable to the project based on the claimant's audited financial statements. First, she calculates the historical exploration costs incurred on the SMP Gold project, recorded in those financial statements. Since Helios audited financials included a breakdown of exploration costs by geographical region, it was a straightforward exercise. The project was Helios' only project in Tanzania, so therefore she included all exploration costs expenditures attributed to Tanzania in those statements. Helios exploration costs incurred on the project between January 2006 and December 2019 amounted to some 33 million Canadian dollars. Finally, as owner and manager of the SMP Gold project, Helio incurred other non-exploration costs which were necessary to progress the project. Where such costs could be directly attributed to the project, Ms. Wall included them in full. Where non-exploration costs were not directly related to Tanzania, but rather general costs and overheads of Helios business, Ms. Wall sought to include only an allocation attributable to the share of Helios business related to Tanzania. She therefore prorated general costs and overheads in proportion to Helios exploration expenditures in Tanzania each year compared with other geographical regions. The non-exploration costs that Ms. Wall calculated are approximately 13 million. Hence, the total historical costs attributable to the project amount to approximately 46 million Canadian dollars. Now, you will hear from the respondent this week that Helios audited financial statements are not sufficient proof, or perhaps no proof at all, of Helios expenditure in Tanzania or on the project. Well, the tribunal should not be overly troubled by these arguments. Past tribunals in investment treaty cases have also relied on audited financial statements as reliable and sufficient evidence of historical expenditure, particularly where respondents have failed to adduce any convincing evidence to indicate the financial statements are unreliable. The present tribunal is in the same position. The respondent has, in spite of all the claimant's financial statements verified by a series of different auditors over a period of 15 years, argued that there is no proof the claimant incurred costs on the project. But it has adduced no evidence whatsoever to suggest any irregularities in Helios' financial statements. In its rejoinder, the respondent argues in response that Ms. Wall's reliance on Helios audited statements is an attempt to mislead the tribunal, since BTL was the local license holder. Now, it is not clear to me why the audited financials of the claimant itself would be inappropriate to determine the costs incurred by the claimant itself. Nevertheless, Helios financial statements were consolidated, meaning they also account for the amounts in BTL's financial statements. In fact, Mr. Mwanga acknowledges that audited financial statements are sufficient proof of historical costs. He expressly argues that if the tribunal applies the cost approach, then the fair market value should be at least the sum of historical costs calculated by reference to audited financial statements. And he does not appear to contest Ms. Wall's application of the cost approach as far as her calculation of historical costs is concerned. Now, let me turn to one of the key issues in dispute on the cost approach, whether to include a reasonable return on historical expenditure. As you know, one of the drawbacks of using historical costs as a proxy for fair market value is that historical costs alone do not account for the success or failure of the exploration in question. As one commentator explains, the results from any specific exploration effort are not guaranteed and may detract or add to the perceived value of the asset in various ways. Hence, the effective contribution to value by a quantum of exploration is not a linear function relating effort to value. Therefore, it is common when using historical costs to measure the fair market value of mineral exploration projects to adjust the historical costs figure in some way, either by increasing it to reflect successful exploration or decreasing it to reflect failure. Where exploration has been successful, one would expect a mineral exploration project to be worth more than the sum of the costs incurred to create it. Where the exploration is a failure, well, the project's value would be below the sum of these costs. Now, the tribunal may not be familiar with the idea of adjusting historical costs to calculate the fair market value from past investment treaty cases. And indeed, when reading previous awards, one gets the impression that tribunals have often used sunk costs as a fallback option or sort of compromise when future cash flows were too speculative without giving too much thought of what they were actually reimbursing. What is clear from an economic perspective, however, is that historical costs without adjustments would only by coincidence equate to fair market value of an exploration asset. Nevertheless, we end up with very few awards analyzing the economic theory behind adjusting historical costs to get to the fair market value of an asset, although there is some precedent that can be found in cases. I would now briefly invite you to engage with me on how to adjust historical costs to reach an economically sound valuation. Applying an adjustment to the historical cost base is a crucial part of the economic theory behind the cost approach. And as we saw earlier in the IVS guidance, the fundamental premise underlying the cost approach is that a reasonable buyer will pay no more for an asset than the costs to obtain an asset of equal utility. But the costs of obtaining such an asset of equal utility would necessarily include an allocation for return on investment. And the IVS guidance therefore explains that an asset acquired from a third party would presumably reflect the costs associated with creating that asset, as well as some form of profit margin to provide a return on their investment. As such, under the basis of value that assume a hypothetical transaction, such as fair market value, it may be appropriate to include an assumed profit margin. The same IVS guidance also advises to include a profit margin or entrepreneurial profit to the creator of the asset, as we have seen before, as part of the calculation when applying the cost approach. Put another way, the hypothetically willing seller in our fair market value transaction expects to receive a return on its investment, on its expenditure, not just the same amount it spent in the past. No investor would invest significant sums on mineral exploration without the expectation of profit if that exploration is successful. On the other hand, our hypothetical willing buyer would be willing to pay a premium over historical costs to use the asset immediately, rather than having to incur the historical costs again and again over many, many years to recreate an asset of equal utility. In addition, the costs of having to recreate such an asset at the valuation date, December 2019 or even 2018, would most likely be higher, significantly higher than when Helio incurred those costs over the previous 15 years due to inflation and other factors. Now, Ms. Wall therefore includes in her calculation a reasonable rate of return on historical costs. She assesses a range of potential rates of return. All of them are based on the concept of opportunity cost. First, she looks at Tanzanian bond rates, based on the premise that the claimant could have made another investment in Tanzania. Second, she looks at the expected rate of return on a similar exploration stage gold project. The assumption here would be that the claimant could have invested in such an alternative gold project. And finally, she looks at the risk-free rate with a margin, such as Canadian Prime plus 2%, on the basis that the claimant may have actually saved interest costs or earned interest on excess cash used elsewhere. Applying these rates of return to Helios' historical costs results in a variation range of between 74 million to 140 million Canadian dollar. Ms. Wall considers the most appropriate rate of return to be 10%, which is the midpoint rate of return for an early-stage gold project. Applying this rate results in a fair market value of approximately 160 million, as I've already mentioned. Now, an alternative approach that we will discuss later this week to adjusting historical costs is the so-called multiple of exploration expenditure, or MEE approach. This method would be applying an adjustment multiple to the historical cost figure, usually referred to as a prospectivity enhancement multiplier, or PEM. Ms. Wall used the MEE method as an alternative to check her valuation using the rate of return. She concluded that her valuation range implied PEMs between 1.6 and 3. As she will explain, these multipliers are within the typical range of PEMs based on industry guidance and market data on historical transactions involving exploration stage mineral projects. I will leave it to Ms. Wall to explain the PEM later this week to you. However, for present purposes, I note that it is intuitively correct that the PEM should be greater than 1 because the exploration that was funded through historical expenditure was successful. And indeed, as Mr. Dennison has explained this morning, the claimant took the project from an exploration area where there was nothing to a mineral resource with over 1 million ounces of contained gold, which had very strong potential for development into a mine, but for the respondent's actions. The respondent denies that it is appropriate to include a return on historical expenditure at all. It does so only based on the testimony of Mr. Bangakala, without referring to any other legal or, more importantly, mining valuation authority for taking this position. Mr. Bangakala's arguments are fivefold. First, he claims that the project was at an early stage of development. Well, the project was not the producing mine, but it was at an advanced stage for a mineral resource asset. As Mr. Mackenzie can explain tomorrow, mineral resource properties are by definition advanced. Indeed, the 2012 PEA alone demonstrated that at a reasonable gold price of $1,450 per ounce, the project could expect to generate future cash flows, implying a net present value of some 46 million US dollars. In any event, as I already explained, Ms. Wall has cross-checked her application of a premium against the MEE approach, which confirmed that her return was in line with industry guidance for significantly less advanced exploration stage mineral projects. Second, Mr. Bangakala asserts that some of the costs incurred on the projects were sunk costs. Now, he ignores the fundamental basis of the cost approach, which is to calculate what costs a reasonable participant would have to incur today to recreate the project. Ms. Wall confirms that a typical participant would have to incur the same costs Helio did, or indeed much greater costs in today's environment. And third, Mr. Bangakala argues that including a premium is not appropriate because the claimant would not automatically have been granted a special mining license. Well, this criticism misses the point. Adding a return on historical costs is not predicated on being granted a special mining license. Indeed, nothing would have stopped the claimant from selling the project in a pre-development stage. In its rejoinder, the respondent appears to concede this point. Fourth, Mr. Mwangakala asserts that the purpose of the claimant's business was the acquisition, exploration, and sale of mineral resource properties. This appears to follow the theme peddled by the respondent that the claimant was a speculator. It reads more like a conspiracy theory rather than economic theory, and Ms. Wall confirms that even if the claimant did intend to sell the project, that is irrelevant for valuation purposes. Now finally, Mr. Mwangakala argues that no return is justified because the claimant lacked the financial capabilities to progress the project. However, this ignores the fact that the claimant's ability to obtain funding from 2016 onwards was, in large part, due to the respondent's breaches of the BIT. Absent those breaches, Mr. Williams will confirm that Helio would have been able to obtain the necessary funding to continue the project. The respondent's only response to this argument in its rejoinder is quite, how should I put this, theatrical. It says the claimant is covering his face while other parts are naked. Now, I'll leave it to the tribunal to find the method in this madness. All in all, the respondent fails to put forward any convincing argument as to why the claimant should not be entitled to a return on its investment. After all, the claimant would never have taken the risk of investing in a mineral exploration project in the first place if it did not expect a return on the amounts invested. Now, what about the respondent's approach to valuing the project? As I mentioned at the beginning, Mr. Mwangakala adopts a so-called adjusted share transaction method. Although he argues it is in an application of the market approach, his methodology is not supported by any of the valuation guidelines on which the parties rely. Mr. Mwangakala appears to have created the method for the purpose of this dispute. In contrast to Ms. Wall's approach, which accounts for the continuous historical expenditure over a 14-year period, Mr. Mwangakala's approach is based entirely on one single reference point, the failed merger transaction between Helio and Shanta in June 2017. The adjusted share transaction method is both inappropriate and methodologically flawed, as I will show. First, the Shanta transaction is a flawed point of departure. As Ms. Wall explains in her reports, it is not a reliable data point to indicate the fair market value of the project at the valuation date. We return to the definition of fair market value. It is the price under a hypothetical arm's-length transaction between a willing buyer and a willing seller. In the case of the Shanta transaction, it is clear from the evidence on the record that Helio was not a willing seller as far as fair market value is concerned. Mr. Williams explains in his witness statements that Helio did not enter into merger discussions with Shanta because it wanted to, but it had to. Since 2012, the decline in gold price and illegal miners at the project had made it more and more difficult for Helio to raise funds for the project. And by late 2016, President Magufuli's actions had made it almost impossible. Helio had already cut its operating costs to a minimum and sold off its Damara gold project in Namibia. Its only option left to realize some value for its shareholders was to merge with Shanta. As Mr. Williams explained, it was a lifeboat transaction. Further, in the negotiations themselves, Helio had almost no negotiation. As Mr. William explained in his first witness statement, Shanta faced no competitors to acquire Helio, and Helio's share price was low. Shanta had waited for the exact right moment to acquire Helio when it had the most leverage. Finally, the proposed Shanta transaction is an unreliable indicator of fair market value in other respects. It was not a completed transaction, but rather Shanta terminated the agreement before Helio shareholders voted on it. Shanta was also a synergistic purchaser. It was only interested in the merger because Helio's resource might be incorporated into Shanta's future mine plans. In other words, the opportunities for enhanced future value were likely the only reason the transaction occurred, and therefore it did not represent fair market value. For the same reason, the Shanta transaction was not a true arm's length deal. Both parties had motivations for the transaction when negotiating its terms, other than the price of Winshear itself. And finally, and importantly, the Shanta transaction took place long before the parties' valuation dates. Hence, Ms. Wall considers that the proposed Shanta transaction fails the definition of fair market value. Indeed, the evidence that we have shows that the Shanta transaction did materially undervalue Helio. You only have to look at the Shanta offer, how it would have priced Winshear at just $11 per resource ounce, compared with Shanta at some $59 per resource ounce. This is a very clear indicator that Shanta had sought to acquire Helio at an undervalue, and that Winshear was under significant duress. The value implied by the Shanta transaction also rests on the assumed value of 59.5 million Shanta shares, and therefore Shanta's share price. However, Shanta's share price at the time was already materially impacted by the economic war Tanzania had started against foreign mining companies, particularly Acacia. Relying on the Shanta transaction, Mr. Mangakala's valuation therefore begins from the wrong starting point. As I mentioned at the beginning, his choice of 18 July as valuation date also means he finishes at the wrong point. But what happens in between? Well, unfortunately, Mr. Mangakala also gets that bit wrong. He acknowledges that the Shanta transaction took place in June 2017, not either party's valuation date, and therefore the value in June 2017 should be adjusted to the valuation date. However, the method of doing so is completely flawed. He simply takes the value of 59.5 million Shanta shares based on its share price at his valuation date and uses that as his fair market value. This approach assumes that the movements in Shanta's share price from the date of the Shanta share transaction to December 2019, or alternatively January 2018, would incorporate all movements to be expected in the fair market value of Winshear's investment during that period. However, as Ms. Wall points out, this approach completely fails to acknowledge that Shanta itself was severely impacted by the very measures the subject of these proceedings here. Investment analysts confirmed, unsurprisingly, that Shanta's share price was driven down by the 2017 legislative overhaul of Tanzania. Now, a picture says more than 1,000 words. Let's not just look at what investment analysts said about the impact of President Magufuli's economic war, but at the share price itself. In this chart, we are comparing the Shanta share price in blue with the ARCA Gold Miners Index in green. As you can see, investors in Shanta were not fond of President Magufuli's populist agenda after his election in 2015. The Shanta share price became significantly more volatile than the index, and more importantly, performed significantly worse than the index. But then, in summer 2017, when the amending legislation was introduced, Shanta's share price literally imploded. So much for the Shanta share price not being affected by the amending legislation. Mr. Mwangakala uses consideration being offered in the form of shares in a combined entity as a starting point, but then uses the variations in the share price of Shanta, actually a different entity than the combined entity, to update his consideration to the valuation date. If he were serious about the approach, he would have thought to calculate the value of the shares in the merged entity. And Ms. Wall will explain that this would have implied an uplift on the value of the shares in a merged entity because Shanta acquired Helio at an undervalue and because there would have been significant synergies to exploit by incorporating the SMP mineral resource within Shanta's business. Now, if one were to follow Mr. Mwangakala's market approach coherently, it would therefore demand making adjustments to the Shanta share price. One, to negate the negative impact of the respondents' actions and omissions on the Shanta share price, and two, to reflect the fact that the entity would not longer just be Shanta, but a merged Helio-Shanta entity. Put simply, the question becomes, what would have happened if Tanzania had never started its economic war against foreign mining companies? If it had never enacted the 2017 legislation and the Shanta transaction went ahead? What if it took its responsibilities towards foreign investors seriously and removed the illegal miners from the Winshear property? What position would the claimant have been in at the valuation date? Well, the fact is, we don't know. Answering that question would inevitably require a high degree of speculation and guesswork as to what might have happened in this but-for scenario. As Ms. Wall explains, because the Shanta transaction did not complete, we do not have the data to consider any share price variation between the Shanta transaction date and any valuation date. However, for illustrative purposes, Ms. Wall tracked the Shanta share price to the ARCA index rather than the actual Shanta share price and applied an estimated 50% uplift to reflect the hypothetical merger. She then estimated that this would increase Mr. Mwangakala's own assessment of loss to between 43 and 77 million Canadian dollars, much closer to her own valuation. However, as I said, this is essentially guesswork. This is why, as Ms. Wall explained in her first and second reports, the cost approach is the best valuation approach available in this case. Every element, every dollar of her calculation is justified by the economic theory underlying the cost approach, and the historical costs themselves are all supported by audited financial statements. The alternative, Mr. Mwangakala's approach, is to take an unreliable starting point and to walk a random path from there. It would be quite a coincidence if you ended up with the correct fair market value. Now, the final topic I wish to discuss is interest. Now, I know interest is not always considered to be the most interesting of topics, so in the interest of time, I will keep this brief. The parties agree that the appropriate pre- and post-award interest rate is 2% above Canadian prime rate. However, what the parties disagree on is whether interest should be awarded on a simple basis or whether it should be compounded. The respondent argues that simple interest should be awarded. Its only support for that position is Mr. Mwangakala's opinion and a single arbitral award where the tribunal appears to have applied simple interest. However, Article 10.3 of the BIT requires that compensation for expropriation should include a commercially reasonable rate for that currency from the date of expropriation until payment. These days, money is simply not available on simple interest terms. Only compound interest would adequately compensate the claimant. Simple interest does not account for the fact that the claimant has been kept out of the interest on its damages as well as the principal. Compound interest also reflects the commercial reality of the sovereign debt market, meaning it would prevent the respondent from receiving a windfall gain by effectively borrowing from the claimant for cheaper than it can borrow on the markets. More importantly, the rate that the parties agree on, Canadian prime plus 2%, is an interest rate that assumes compounding rather than simple interest. In other words, if simple interest were being applied, a much higher rate would need to be chosen to adequately compensate the claimant. As an example, the Tanzanian statutory interest rate, which is applied in simple terms, is 16.7%. Now, for all these reasons, compound interest has become the norm in international investment arbitration. And that, members of the tribunal, concludes the claimant's opening submission.
Thank you very much. I don't know whether my colleagues have questions, other questions at this stage. I will have some, but I think it makes more sense that we put them to you in an organized fashion. We were thinking on Wednesday at the end of the hearing, so when you, on Thursday afternoon approximately, before we end, you can then answer that. Would that be fine?
Whatever you prefer, Madam President.
Yeah, I think, is it fine, or would you prefer to ask questions now?
I agree with you.
Yeah. Is it fine with the respondents as well if we proceed like that? Yeah.
Anytime.
Good. Fine. Then I think we can take the lunch break now. It is 1 o'clock, so we would start again at 2 and then listen to the respondent. Is that a good timing, Dr. Luenda? Yeah. Good.
Yes.
Fine. Have a good lunch, everyone, then.